Every, good morning. Good morning, everyone. Council is convened for interviews for two vacant district court judge positions. We are going to start out this morning talking about potential questions. And I think there was a recommendation, maybe no more than 8, because we have 45-minute interviews. So I think, Counselor Young, I know you kind of reworded a few of them. I like all of the rewording because I think it captured multiple points in this long list of potential questions. Other thoughts?
I've not looked at that list.
Here is that list,
you.
so you can have a moment to look at that. Counselor Young, did you want to? Well, and the other thing, I like a lot of these questions. Yes, I can. Okay. Question 8, I think, is a natural last question to ask. And I liked question 9 and 12 and 13, although I'd be willing to give up 12. And although I was interested in possibly asking about conflicts as an additional question. Counselor Belcott, we have our back to you. I apologize for that. But if you have anything you would like to add, please chime in.
Yeah, I wasn't able to unmute myself until just now. I like the list that Counselor Young sent to us as well. I saw that email. Thanks, Counselor Young, for doing that. I was bringing that up to kind of compare and contrast to the other email that we received from the county manager. So I'm going to bring that up in just a second.
Okay. Any other feedback related to any of the questions I suggested, if it seems like, or if it seems like too many?
Did you say 12, but you could let that go, and then also 13? Did I hear that correctly?
Yes, I think 12 you may have captured in some of your rewriting of some of the questions. But 13, I think I'm still interested in that. But I'm absolutely open to what other suggestions you all may have.
I like 13 as well.
I have to say I agree also 13 is good, but I do also like 8 and 9, your recommendations as well.
Okay, great. Yeah.
I think those that were reworded by Counselor Young, the 3 that you selected, Chair, they're fine with me.
Okay, we're very agreeable this morning, so that's a good sign. I will be making some opening remarks, but then I think we need to divvy up these questions as far as who asks what when.
And then
Oh, and we should renumber them too
yes,
to make it easy.
number 8 is the final question, correct?
That's the last question. So it is 8. It will be question 8.
Oh yeah,
And-
one works out.
One of them will work out. I'll go ahead and take that one. Anyone in particular that anyone wants to ask?
Which ones did we eliminate? Did we decide on that?
We eliminated 1, 2, 3, 4, 5, 6, 7, and 10. And then 11, 12, 14, 15, 16. And then we'll need to number the
I'm sorry, 11, 12, 13,
11, 11, 12, 14, 15, 16.
So we're asking question number 10.
and 10, we're eliminating
Eliminating
10.
10. Okay.
Of the list that the county manager sent out, we are asking number 8, number 9,
13.
and number 13.
Okay.
And then many of those questions are captured in the summary that Counselor Young put together. Okay, Counselor Young, I'm assuming you have a copy of this? Okay. Put that in the bottom of my pile. Okay, who would-
Renumber them though. Let's see. So we've got 1, 2, 3, 4, 5.
Okay, yes, so we'll just go down the list of Counselor Young's questions and number them 1, 2, 3, 4, and 5.
Okay.
And we can alternate asking questions. I'm gonna take the last one, and I could take the first one as well.
Okay, just to be clear as well, we're renumbering number 8 to number 6, number 9 to number 7, and number 13 to number 8 for a total of 8 questions.
Oh, good job.
Just to avoid confusion.
Well, except for we wanted number 8 as number 8.
Yeah, so 9 will be 6. It's always the confusing part. 13 will be 7,
Okay.
and 8 will remain as 8.
Okay.
So I'm taking so we each get 2 questions. I'll take the first and the last.
Okay, just to be clear, because I'm reordering mine electronically right now. So Counselor Young's questions were numbering 1 through 5,
Correct?
correct? Okay. And then 8, 9, and 13 from the original questions that were sent out will be following number 5.
They will follow number 5, and number 9 will become number 6. And number 13 will become number 7.
Okay.
And number 8 remains the same.
Got it. Thank you.
I can ask number 2. And number 5.
Okay, and others? Counselor Young, which ones would you like?
I could do 3 and 4.
Okay. And then by default, Counselor Belcott, you will take number 6 and number 13. Well, I'm sorry, number 6 and number 7, formerly 9 and 13. Oh. Okay, are we clear? If we get mixed up, I think I'm clear on the list, so I'll give you a nudge.
As am I.
Okay. So I think we're clear on our questions. I would say if the first candidate is here, perhaps we can get started.
Can I have a moment just to put my things in order?
Absolutely.
Thank you.
We'll just take a pause. Give us a heads up when you're ready to go. Thank you.
And Mike said, no,
He will or won't? Okay.
is the management team
yeah.
afterwards, but it's virtual,
I-
so.
Okay.
How was your weekend, besides the cat barfing on your
Yeah.
floor?
That was not fun, but otherwise good.
Was it just a one-off, not?
Yeah, Chu eats wet food so slowly, so I think I just had the same can in the fridge too long.
Oh,
Like, better to blame that on him.
and muted now. Sorry about that. No, I don't want to. No.
There's like not enough room here.
Oh, he's dabbling. Yes, please look at it.
Huh?
You can spread out down there.
Uh-huh.
Counselor Belcott, are you ready?
No, can you just give me a few more minutes? I'm sorry.
You have 1 minute.
Counselor Belcott, we're going to be bringing in the first candidate.
Chair, just to make sure, can you tell me what my questions are again? I'm sorry.
No
6 and
problem.
7?
They are 6 and 7.
Thank you.
Good morning. Welcome. We'll let you get settled in there. I know we've been shuffling our papers around for quite a while already, so.
There always seems to be the paper not in the right place. Make sure you put your.
Oh, you need to press your button there to,
There we go.
yeah,
Yes.
there we
Okay.
go. Okay.
All right.
So welcome very much, Erin. Thank you. We really appreciate your applying and coming in today. We will be interviewing for 2 positions. We have about 45 minutes for each interview. And I just would like, we have 8 questions, so we don't have really a lot of time for answers for each question. And I just want you to know that this, there's members of the public that are online watching and in the audience. So just be aware of that.
Okay. Thank you.
Okay. All right. So we're going to take turns asking you questions. And I've got the first one here. Given the description of this position, please tell us how your unique qualifications and experience make you the most suitable candidate for a district court judge, and articulate your primary motivations for seeking this particular role.
Okay. Great. Thank you very much. So, and thank you for the question. I have been a Clark County District Court Commissioner for 4 years. In the role of commissioner, we do about 80 to 90% of the same sorts of tasks that a district court judge does. The primary difference between a commissioner and a judge is one who appoints us. We are appointed by the bench themselves, and also typically commissioners don't hear trials. We can, but it would have to be by party agreement. So at this point,
I don't think I am.
I'm sorry. So at this point, I am uniquely qualified because for the past 4 years, I have been doing essentially the job of a district court judge, but for the trials, I don't think there's been a commissioner that's heard a trial in quite some time. So I have been doing that. Prior to becoming a district court commissioner, I was a pro tem judge, meaning a substitute judge, if you can think of it that way, for about 5 years prior to my appointment. I have heard every single docket area of law that district court does that we decide. So there's not a docket or anything that I have not done for district court. Additionally, when I was an attorney, I made a point to make sure that I had experience in the things for district court. This has been a long goal of mine to be a district court judge. So I have practiced criminal defense. We are largely
Testing.
I don't know that.
Are we okay?
It must be someone. Oh,
I
you're
see.
just fine.
Is it okay for me to keep going?
Yes.
Okay. So I have been a defense attorney in district court for indigent clients. I was a public defender. I took private defense cases. I have represented folks in civil matters in district court. People who have been houseless all the way up to folks who have quite a bit of money. So I have run the full gamut in terms of what district court hears. And then lastly, just to the point of my primary motivation for seeking this position is I feel that I feel very strongly that this job is a vocation and not just a role of the court. This job does not begin and end with putting on a robe and making decisions. In fact, that would be a rather easy thing to do. There's a lot that goes on with this role that having served as a commissioner for 4 years, I absolutely love it. I feel called to it, if that kind of makes sense. I have just enjoyed every aspect of what being a commissioner has allowed me to do, and knowing that this is the right fit for me going forward because I understand the job intimately.
Great. Thank you very much.
Good morning, Arian. Thank you for being here.
Thank you.
So question number 2, describe your direct experience with the specific dockets and functions of the district court, such as presiding over jury trials, protection orders, or various criminal and civil hearings. Now, based on this experience, what is the one significant challenge or opportunity you foresee for the Clark County District Court in the next 5 years, and how would you, as a judge, propose to address it?
Okay, thank you. So yes, trying to not be duplicative of something that I've already mentioned, but I have the only thing that I have not done in my role as a commissioner, again, is here jury trials that is reserved for the judges. It's just not typically a task that the commissioners do. I have presided over literally every other docket that we have. The protection order docket can be a little contentious, of course. Those have very real consequences for both parties who are involved in those. So that takes a lot of skill to make sure that there's fair opportunity for everybody to be heard, but also maintaining decorum and that folks don't get, too rambunctious. That kind of feeds off of the testimony itself. The criminal dockets, they're big. I don't think we have any small dockets anymore. I'm sorry, it's hard for me to tell how
You're doing
if I'm doing okay.
fine. Yeah, you guys great.
Thank you. With regard to microphone. So we don't have any small criminal dockets really at all. So the experience that plays into this role is being prepared, knowing the cases that are on, having a good system to move through that docket efficiently, again, making sure everybody can be heard, but also there is a time constraint. So to move through everything. A challenge that I think that district court has in the next 5 years, we have issues with funding for indigent defense. We have issues with funding in our community partners in terms of, for example, the prosecutor's office for both the county and the city. They don't have nearly the personnel and staff that they used to, so this impacts our dockets quite a bit. There's a lot of considerations that go into these things. For a judge, we do have a duty to make sure that everyone's given a fair hearing, that the right to counsel is protected and upheld. It's a fundamental right that we have. A judge can work with the community partners to come up with creative solutions on how to address these things. And just to choose, one of them, there's collaboration that can go on with the prosecutor's office, the defense attorney's offices, to ensure that the dockets are manageable. We are currently doing everything that we can to make sure that there's a right to counsel for everybody who's there. When we are just missing number of attorneys, then we have to essentially look internally whether or not the court can pause certain hearings, certain things. Do we have to appoint attorneys on? Can we combine them? There's lots of considerations there that can be explored. That being said, I definitely want to state that the court doesn't have the ultimate authority over that. That is, there's some separations there. So it would have to be a solution that works for both the prosecutor's office, the indigent defense office, and the court to kind of keep things going. So by and large, the biggest thing there is to collaborate and come up with the best possible solution with all of those interests in mind.
Good morning, Aaron. Thank you for being here, and it's a pleasure to be able to meet you in person.
Good morning as well.
So, again, you started to touch on this just a little bit in your last answer, but how do you ensure that every individual who appears in your courtroom, regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to justice?
Thank you very much. The primary, and in fact, it's it's an ethical mandate of judges to make sure that everybody in front of them is entitled to an impartial, fair hearing. Ensuring that inside of a courtroom requires, number one, preparedness. You've mentioned, Counselor Young, about people who might not speak English. It's there when you're preparing for a docket, you need to, be looking to see, are there folks on this docket who need an interpreter? Has it been flagged in the system yet, for example? So then you sort of know how to address those cases, also to let them know when they come in, I understand that you need an interpreter. We have one coming for you. And I think that in and of itself makes people feel already kind of heard and included, and that they aren't sort of lost in the shuffle. So I think number one, preparedness. Number two, for impartiality and ensuring a fair hearing, you have to be able to listen. And a judge cannot be guided by anything other than what the facts of the case before you are and what law applies. Cannot be guided by who does the judge like more, which attorney do they know better, which outcome would the judge particularly personally like. None of those things can be considered. It is required of a judge to fight their own biases. Everybody has them. There's no finish line to that. That is a lifelong continuing skill to make sure that you are staying abreast of things that might be impacting your decision making, both consciously and not. So all of these things together do require, a judge to remain impartial and ensure that everybody in there is feeling heard, giving them time. And if you run out of time, tell them, it just being upfront and being transparent with people, I think really helps folks feel that they are part of the process, that they are not being overlooked, and that I hear you. I'm just going to have to take a break and come back to your case. I need a couple more minutes, something so that people don't feel like they're just being overlooked.
Great, thank you. So please describe a specific instance where you were faced with a difficult decision or a challenging situation that garnered significant public or professional scrutiny or pushback. How did you navigate that situation? What principles guided your actions? And what, if anything, would you do differently looking back? That's kind of a long one, so if you'd like me to repeat it, I'm happy to do so.
That's okay. I think I hopefully wrote enough buzzwords here to remember everything. So there is a case that off the top of my head comes to mind. And I wouldn't say that it had public scrutiny to it, but certainly I ruffled some feathers of some attorneys, I'll put it that way. this was a case where somebody had multiple DUIs. Our state law requires that when you have multiple DUIs, the court is required to sentence in a particular. We have mandatory minimum penalties that the court is not allowed to go below when you're sentencing somebody. This was on a sentencing docket, and there was an agreement that had been reached between the defense and the prosecutor about this case to essentially reduce this charge to something that was not a DUI. And then to put this person into a specialty court, and this person had multiple priors and essentially had asked me to give a very light sentence and put this person into the specialty court. The history of this person, again, had multiple convictions. Also, this person had received several reductions in their criminal history before, meaning DUIs that had been amended to different charges before. Now, this specialty court that this particular person was going to go into, it does not save you from the mandatory minimum. So even if you're sentenced and go into this court, you still have to do the jail time or the home confinement or whatever. It doesn't save that part. There are people who are in our jail right now who are enrolled in this therapeutic court, but they are sitting out their mandatory minimum sentences. I did not ultimately think that it was a fair resolution given the history here. I allowed the amendment. That's something that's worked out between the parties. I didn't stand in the way of that, but I did have some concern about the sentencing recommendation. So I didn't accept it. And I had ordered this person to serve some jail time, albeit not the mandatory minimum, because it'd been reduced to a charge that doesn't require a mandatory minimum sentence. That was an unpopular decision for this particular attorney and some other, maybe some others who had heard that. The concern was that the court is, kind of getting in the way of agreements, and this person's going to do a specialty court, and there is a lot of supervision there. But ultimately, I'm looking at this courtroom full of people, some of whom I'm also going to be sentencing and taking to jail that day. It's fundamentally unfair to have somebody who has an attorney and maybe private counsel who's paying a lot of money to receive a particular favorable outcome when there are other people who are sitting in the courtroom that day who are not going to fare as well. Their attorney doesn't have that kind of agreement. There could be lots of reasons for that, but ultimately I didn't think it was fair. So I did not follow that sentencing recommendation. I would not, and subsequent to that, then, there were, I was affidavitted, meaning that there were people who were filing pieces of paper that says, I don't want Aaron Priest to hear my case, and it would get transferred to somebody else. And that's a risk. And you could think of it sometimes as a consequence, I suppose, if people don't like the decisions that you make. Looking back on that, part of the question is, what would I do differently? I don't actually think I would do anything differently. That decision I made I was talked to by a couple of the judges about it. I would not change anything that I did there. And the reason why is because you have to have the courage to make unpopular decisions in this job. That is what keeps the integrity of the court. And that's what I'm not saying that it's easy, but it is, that's part of it. And I recognize that not everybody is going to like or agree with my decisions. However, as long as they are grounded in what the law says and the applicable facts are applied to what that law says, then and blindly so, meaning, not paying attention to, again, who their lawyer is or what their background is, et cetera, for their financial positions and things like that. So it is not, I wouldn't say that it's an enjoyable experience, but I do think that it is, our system depends on people having the courage to make those types of decisions.
Thank you for that. I think we can relate to that.
Yes. Yes.
Yes, we can. Thanks, Erin. Question number 5. Beyond your duties on the bench, how do you envision a district court judge actively contributing to the community and fostering public understanding and trust in the judicial system? Can you provide an example of your past involvement that demonstrates this commitment?
Yes. So I think that being a judge, earlier when I had mentioned that it's my very firm belief that this is a vocation and not just a Monday through Friday, 8 to 5, put on a robe and make decisions job. It does require a commitment to the community. Judges, while upholding their other ethical responsibilities, meaning that we do have to walk a fine line in terms of what we can do in our personal time, and even in certain professional capacities, we have got to maintain our impartiality, integrity, and independence. And anything that basically threatens that could potentially be a violation of our Code of Judicial Conduct. However, I do think that outreach is important for people to be familiar with the court. District court, we receive a lot of our folks in district court. This is their first contact with the court system whatsoever. That can be a very scary experience for people. So I think anytime we have an opportunity for outreach to essentially, kind of demystify that for people, or to humanize it, that they don't feel like it's going to be this big scary experience, the better. Examples of what I have done in that capacity. I have basically, since I became an attorney, I have served in the mock trial competitions with youth. So there's every year a middle school and a high school competition where they have a case and they come before the court, they argue the case. I have served as a rater or a juror, you can think of it, and also a judge in those competitions. And I think that has been so wonderful to kind of get in contact with youth who are interested in the legal system. Additionally, I have participated in an event called the Colors of Justice, which was organized by Superior Court Judge Searing Cornell. And that was geared toward women of color, and just really women in general, but I do think more geared toward women of color in their interest in the legal community, and kind of getting going forward and listening to all of the ways that women have, what kind of paths women have taken to get into the legal system. Do you want to become an attorney? Are you interested in becoming a judge, et cetera? Give them an opportunity to, again, ask questions. And at that event, we had Supreme Court Justice Whitaker down. So we do have, a lot of interest kind of all the way throughout our state for those things. So anytime that we can, again, do outreach of any kind going into schools. We participate in lots of little professional groups, Inns of Court, for example. That's a way for attorneys and judges to collaborate with one another outside of the courtroom and get to know each other. All those things I think are vital in getting the public and folks familiar with the court.
Thank you.
Good morning, Erin. Let me know if you can hear me okay. We were having some sound issues earlier.
Yes, I can.
Okay, great. Thank you. What do you see as the unwritten responsibilities of a district court judge? How would you meet them if appointed?
You said the unwritten responsibilities?
Yes, ma'am.
Okay, thank you. Yes. So there, I think, are actually quite a few. Number one, I think maintaining a healthy work environment is something that is very important. As a district court judge, you're essentially, responsible for everything kind of that goes on inside of the court. So I think it's an unwritten responsibility to care about the organization, to care about the people who work there, and make sure that there's good work environment, and if not, to address those things. A second unwritten responsibility, I think, is maintaining and fostering relationships with our community partners, with the court partners that we need to work with all of the time. As I know, as the county council here, you are very familiar with lots of issues that arise between various agencies that do have to work together. It's very easy. Again, the easy thing to do is to just dig your heels in and decide that you're going to take a position and that's it. And I do think that it is a responsibility, unwritten responsibility of a judge to stay plugged in, to stay open, to listen, to show up. It's the easiest thing in the world to shut down and just say, well, we're going to do this or that, and they can do that or this, and we can just sort of all but the reality is that the court, and for our partners, it is an ever-changing landscape. There are cases that come down all of the time that affect maybe one party or another, or just the court itself. So it's important to maintain and foster these relationships. And how I see myself doing that is, again, just staying open, staying engaged. It is it's a commitment to just not closing a door when maybe that would be the easiest thing to do, because we cannot keep the legal community going. We can't keep the court going if we can't collaborate. So, and provide a healthy work environment. If we're constantly having a bunch of turnover, for example, that's of no benefit to anybody either. So I think that primarily those two things are very relational, and they are vitally important to continuing the court and making sure it's growing well.
Thank you. My next question is, describe your personal decision-making process.
So I hope that I am not sounding like a broken record here, but I have been accused of being an over preparer. So I think preparedness is a large part of my personal decision making. I like to know what is before me. I think that is. I think that's a responsibility of a judge. It's people are coming before you to decide a dispute. You need to know what that is. Showing up and not having a good grasp on that does everybody a disservice. And that's, antithetical to what the job actually is. So for me, it is a lot of preparedness, a lot of reading, a lot of question asking. If I don't know what this is, I certainly try to find out who does know, ask other judges. We judges in the state we have a listserv that we can ask one another in different jurisdictions, or what do they have this? Is there somebody who might be have a little bit more expertise in it? So all that to say that I like to prepare. I like to know what's in front of me. I think that I can give a more valuable hearing to folks when I do that. When I give my decision, I think that I would best describe that as thorough and firm. I think that those are important things for judges to not be subject to, they didn't like that. Oh, someone's upset. I better change my mind. That's just not really part of the role. So I do think that in my decision making, it's thoroughness, providing an impartial and fair hearing to them, and again, giving a thorough and firm decision.
Great, thank you.
Thank you.
Here we are, Erin, at the last question.
Yes.
So is there anything we've not discussed that you would like us to know when considering you for this position? And do you have any questions for us?
Well, I think that I have essentially, through all of these questions, hit on everything that I wanted to say, but in terms of my qualifications and things. But I also just want to stress that I am so happy to be here. I've been looking forward to this for a long time. I'm very grateful for the opportunity to be here and to be given time by the council to talk about this. I love what I do. I have never, ever wanted to be anywhere else except district court. When I was an attorney, with this being my ultimate goal in mind, I have turned down jobs that would have been more lucrative. They would have created more conflicts for me. I have turned down things that I thought were taking me maybe in a different direction and away from district court. I have always loved district court. It feels like home to me. And I had shaped my entire when I was an attorney, legal practice around being able to stay in district court and not get too far from it, so that I could very much one day be right here and asking to be appointed a judge. I can tell you that I know what it takes to do this job, as I've been doing it for 4 years, and it is not an easy job, and one that should not be just done lightly. There's a lot that goes into it, and I've been very grateful for the opportunities I've gotten to be in district court as a commissioner, and very much, hoping to become the next district court judge as well. I don't really have any further questions of you folks, other than if there's anything I could say to further convince you. But ultimately, I really just appreciate your time and being here, and this entire experience has been great, and Michelle has also been wonderful. So thank you very much for your time.
Great. And thank you very much for your time. We really appreciate it and all your thorough answers. Just a couple of things I'd like to say. This is a public process, so we're in a public meeting right now. We will go, when we conclude the interviews, we'll go into an executive session to deliberate for a brief period of time, and then come back into a public session to reveal any decisions that we've made. So I'm imagining that'll be around 3:00 this afternoon. So you could tune in if you like.
Okay, I
as
will.
well.
I absolutely
And
will.
I had meant at the beginning of the meeting for us all to introduce ourselves. So maybe we could do this because we've got a couple minutes right now. So I'm Sue Marshall. I represent District 5, which is the northern half of the county geographically.
Yes, it's very nice to meet you.
I am Counselor Young. I represent essentially Vancouver city limits west of I-205, which is District 1.
Okay, nice to meet you.
Councilor Fuentes, District 3, East Vancouver.
And Councilor
Counselor,
Belka?
Counselor Michelle Belcott. I'm Salmon Creek, Philida, Minnehaha, Hazeldale, and out to Five Corners.
Wonderful.
Great.
Thank you.
Again.
Thank you all very, very much. It's been a pleasure. Really, truly. Thank you.
Likewise. Thanks. I think we may just have time for a couple-minute break if anyone needs it before our next candidate comes in.
Do you want me to push this off?
Just remember to push button when you. When push button when I'm talking.
Right.
Just leave it on.
Yeah, you can leave it on through the whole interview.
Okay,
Yeah.
perfect.
I'll go ahead and get us started.
Thank
So
you.
thanks for pushing your on button there. So welcome. Thanks so much for coming in. We appreciate it. We are interviewing for 2 positions for district court judge, and this is a public process. So there are people online observing and people in the a person in the audience observing as well. So I think for starters, we'll go ahead and introduce ourselves. I'm Sue Marshall. I chair the council. I represent District 5, which is the northern half of the county, generally geographically. So go ahead.
Yes, I am Counselor Young. I'm District 1, which is the west half of Vancouver from 205.
Councillor Will Fuentes, District 3, East Vancouver.
Nice to meet everyone.
Counselor
Oh, sorry,
Michelle
there's one more.
Burkott, District 2.
Great. And so just to let you know how we're proceeding, we have, it's 45 minutes. We have 8 questions, so you can kind of judge your time that way. And we'll take turns and we'll just get started with the first question.
Thank you.
So given the description of this position, please tell us how your unique qualifications and experience make you the most suitable candidate for a district court judge and articulate your primary motivations for seeking this particular role.
Sorry, just give me 1 second.
That's quite all right. There we have, some of them are kind of long questions.
So I just want to make sure I'm getting my points. Well, I would say my unique qualifications. I come from someone who's had a lot of experience in district court. I started out in district court. I think I mentioned it in the forum that my first job was first appearances, mostly in the jail every afternoon, representing indigent clients at those hearings, and gradually moving up. And the first 5 years of my career was spent entirely in district court. I have done every docket there is to do in district court. I have been in front of every judge, every commissioner through the last, 19 years really in district court on a regular basis. So I have that historical experience, that historical understanding. I also really learned from day one how important everyone's role is in district court. The jail's role is essential to making district court run. A judicial assistants are essential to making sure that courtroom runs well. Interpreters, prosecutors, defense attorneys, everyone needs to work together to make these dockets run as efficient as possible. And that has become more and more important with the changes in district court. I think our population since the time I began as an attorney is up around over 20%. And there's been an increase in that equivalent of cases in running through district court. And it requires everyone to be well-versed in what needs to happen. It requires a focus on efficiency while also making sure from a position of the bench that you're maintaining control of the courtroom, your authority in the courtroom, and most importantly, being in that impartial decision maker. So I have a deep understanding of that given my history in district court. I will also say I've had the ability to go and expand my knowledge. I've worked in a lot of other different areas. I moved to Superior Court and did all levels of felonies there and got a lot of trial experience at the felony level, which I think is important. I do civil commitments. I am currently doing juvenile cases. I've done guardianships, some probate. So I've gone and explored different areas. And what brings me here is that I keep coming back to district court. I came back to my original office after I had my second child. And, that was primarily because I enjoyed the people I worked with. I enjoyed the type of work we did. And I wanted to get back to that. So I really, really enjoy district court, the people that are there. And what I will say about district court is I think it's really a reflection of the community and the community's issues. I listened to Ms. Marshall's State of the County address from this year, and everything you mentioned is something we see in district court every day. And that is housing issues, dealing with the homeless population, dealing with substance abuse, dealing with the mentally ill, dealing with budgetary issues. Those are things that are seen in district court every day. It's things I work through as a defense attorney. I just feel at this point, I am really ready to take the next step to be on the bench and assist in that way. And I see district court as an opportunity to be able to assist and address some of those community issues on a daily basis.
Thank you.
Good morning again, Megan. Question number 2. Describe your direct experience with the specific dockets and functions of the district court, such as presiding over jury trials, protection orders, or various criminal and civil hearings. Now, based on this experience, what is one significant challenge or opportunity you foresee for the Clark County District Court in the next 5 years? And how would you, as a judge, propose to address it?
So looking at my particular experience handling dockets, I would highlight a few things from my resume. The first thing, I'm going to be repeating myself, is the experience in district court. A public defense attorney has I would say, a unique responsibility in how a district court docket runs because they have most of the cases. So you typically have half or over half of the cases that are on the docket for that day when you're the public defense attorney. And so being prepared is essential. Knowing what is prioritized, which in district court, you're looking at who's in custody, who needs an interpreter, who's mentally ill and may have difficulties being in the courtroom. It's the public defense attorney who's really handling a lot of that and seeing a lot of that first. And if you are prepared, if you're ready, if you're knowledgeable, you can really assist in making that docket run smoothly, which leads me to my second thing on my resume I would highlight, which is my role as docket deputy in Clark County Superior Court. I acted as a docket deputy for all defense attorneys on the first appearance docket in Superior Court for almost 3 years. It was a new position and created to try to assist the individual contract defense attorneys with assistance on the docket. And this was before, of course, we've created the new public defense office, and we had never had that support for defense attorneys. And I was, excited to take that role. And I really tried to build it into something that was useful, not only to the defense attorneys, but to the judges. And being able to be on that docket every day to keep, I kept really important notes in terms of clients because they would, defendants would come, they leave, then they come back. And I would really make it a point to make sure that I was able to provide the relevant information to the court, to the prosecutor, to help the case, the docket run smoothly. But I also, had a duty to talk to all, any defendant as needed. I didn't know day to day what I would be doing or who would I be talking to, because a lot of times it was just on an as needed basis for coverage. And, if you look at my resume and my references, my work on that particular docket, I think is one of the reasons so many Superior Court judges were willing to be a reference more for me and doing that work and understanding the importance of that work when it comes to managing a docket. I would also highlight my pro tem experience in Clark County Superior Court. In Clark County Superior Court, when you're a pro tem, you're doing family law dockets essentially mostly. So that's something I did not have experience in as an attorney. So coming in as a pro tem commissioner, I had to learn a new area of law. I had to prepare and review those cases in an area that I had not done before. I had to make sure that I sought out help from other judges and commissioners before I got on the docket, sometimes during the docket, or sometimes after the docket, to make sure I made the appropriate decision, the impartial decision based on the case law, the facts at hand. So it was certainly, I think, a confidence booster for me to be able to go in and do something like that, to manage the dockets, which I was handling no contact order dockets, family modifications, dealing with parenting plan, visitations, people that were very stressed and emotional about these issues, having to work through that and make a decision based on the law. So I thought that was great experience and would really help me on the district court bench and certainly gave me confidence that I was ready for this position. And then finally, my role at Vancouver Defenders, I'm a supervising attorney. I take that seriously. I've had the ability to come in and be in a lot of meetings to understand a lot of higher level issues that maybe a regular attorney wouldn't be able to understand in terms of budgets, how they work, limitations of budgets, explaining that to attorneys, training attorneys, hiring attorneys, and support staff, being involved in meetings and for decision makers, and being a voice for our office when needed at those meetings. So I think that's great experience, and it also helps me understand the differences between the city and county. I would say that there is different interests, different priorities based on the type of cases you see on the city dockets versus the county dockets. And given that my office has done both of those cases over the course of those 19 years I've been an attorney, I have a deep understanding of that as well.
Thank you, Megan. I want to follow up really quickly. The second part of the question was if you, based on your experience, have you identified any significant challenges? And if you were to be selected for district court, how do you propose to address those challenges in the next 5 years?
Thank you for reminding me of that part. I will say the first thing, well, the first thing that comes to mind is what I mentioned earlier, is that district court sees all those challenges in the community that we see on a daily basis in terms of dealing with people that are struggling with mental health and substance abuse. I would say one of my incredible strengths is my ability to work with those that are mentally ill. I was a defense attorney for mental health court. I am currently an attorney for civil commitments, which are those that are hospitalized for involuntary mental health holds. So I have a high level experience on that, and I think that's important and would be a challenge for anyone entering the bench in district court. You need to be able to learn that skill or have that skill going in, and I feel I have that skill going in from day one. The other challenge for district court right now is the amount of cases that are being seen on the docket. As I mentioned, population has increased. The amount of cases have therefore increased over the course of the 20 years I've been here. We haven't had an increase in judges though. So we have the same amount of dockets with more cases, and everyone feels it. I know the prosecutors feel it. I know my attorneys at my office feel the pressure of these additional cases. And so I know if I were to go into this position as a judge, I'm going to feel that pressure, being the final voice, the final decision maker in the courtroom, handling these large dockets. So I do think it's important to have a deep understanding of that. I think it's important, and certainly I've been advocating for it, to, figure out ways to be able to resolve some of these cases as they come up on the docket. When COVID hit, we kind of changed the way we did things in district court. We weren't having people held in custody as much initially, and that allowed us to maybe set things over to do resolutions, not handle things as we used to when they were ready to be resolved. So previously, a lot of times if we had a case that was ready to plead out, the client wanted to resolve because they were in custody, because they were homeless, and it's going to be very hard for them to come back to court. We were able to do that. We can't really do that when we have 100 cases to do in 3.5 hours. So that requires us to set over, and then we lose people because then they're not able to make it back to that court date. And then they're spending more time in custody because they're getting arrested on warrants. And it becomes this revolving circle door of seeing clients and then defendants do more jail time. And that's a risk, of course, to the county. And I don't think it creates community safety. We want to resolve cases. We want to make sure if they need to be on probation that we're getting them there, we're getting them resources as needed. I think that's something the district court is able to do, to be a place to provide resources. So I think that's important. And I would certainly be an advocate to figuring out the schedule in a way where we're back to more being able to resolve cases as they come up as needed. I think that, a lot of judges want to make sure that we have everything proper and ready to go in the best place possible. But I do think we have to balance it with the realities of the people that are coming into the courtroom and the needs that they're facing. And so I would certainly be an advocate for that on the bench, and trying to make sure that our dockets are in a way that they can be efficient. And by efficient, I mean being able to do the cases as appropriate as we should be doing on that particular case, on that particular day. So I do know where the court is moving to the new building. There's going to be a change in schedule. I know they're going to hope to address some of these issues. But of course, I think there's going to be further adjustments that need to be made. And I feel like I would be a very good voice to have One, having a defense perspective and knowing what that work looks like and knowing the limitations maybe that side's facing, but more importantly, just my experience being on the docket, knowing, the impacts of the legal decisions that the court makes on people and seeing that after they leave the courtroom is, I think, something as a defense attorney having clients is unique and important.
How do you ensure that every individual who appears in your courtroom, regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to justice?
I think there's several different things you can do, but from the position of a judge, I think one, is important to create authority in your courtroom and to create that respect for your position in the courtroom and understand your role as the judge. I also think it's important to make sure people see and understand that when they come into your courtroom, you are giving both sides time to make their arguments, to have their issues known as appropriate. And that starts at the first hearing, at first appearance. I think there can be a tendency because to people that are in court a lot, some things to us seem very redundant and simple and not a big deal. But for the people coming into court, it's scary, it's stressful. There's victims who have been traumatized and are scared to come in. And so you want to understand that. And I think I will want to make sure, especially starting out, that I'm taking that time, even if I run into lunch, if I'm going over, to make sure I'm taking that time from the beginning of the case. I think the beginning is so important to establish that expectation and that understanding, because my goal will be when people leave the courtroom that they may not be happy with the outcome, they may be frustrated, but I don't want them to leave thinking that the judge, me, did not hear each side's and didn't take into consideration the law, the facts of the case, how they apply to the law, and made a clear decision that was based on the law. And while doing that, treat people with empathy. So definitely giving them that time. I would also highlight need for interpreters, creating an environment where that's necessary and that's expected, and that you have the appropriate interpreters for the different needs. Something I've seen over the course of these 20 years is that we have different types of interpreters that are now needed. We have different communities in Clark County. When I started, we would have a Russian interpreter, a Spanish interpreter most days, and ASL because of the state school. Those were all very regular. Now we have our primary is Spanish and Chuukese. So there's a difference in those communities and cultures. And I would say from knowing and representing clients, they are more, English as a second language speakers are more likely to downplay the need for an interpreter and to say that they understand and say, yes, that's okay, when really they don't understand. And as a judge, I want to make sure that they're understanding my conditions I'm setting out for them if they're a defendant, if I'm giving them a no contact order, what that means, if I'm giving them a sentence and they have to go to probation, that that's going to happen and they understand what they need to do. And I need to make sure as the judge that I am showing the importance that they are getting the best possible resources to understand that. And that is listening in their own language. And I have been, susceptible to that as an attorney sometimes, thinking, okay, you've been here 10 years, you're speaking English very well. And then, really realizing like best practice, what should happen is really making sure that they hear things they can hear in English, but that they also hear in their own language. Because what we want as a court, what I want as a judge, is for my court orders to be understood, that they have the best chance of being followed, and that is what creates a safer community. Another thing I would highlight that's really helped with resources, and I think creating equality, is Zoom appearances. That really was made out of COVID and necessity. I was really impressed with how quickly district court implemented that back then. They were very fast to get that running. They also were the ones that already had video in the jail, so we could utilize that. And I think it's been a great tool to allow people access to the court in a easier manner as needed. I've had clients appear from tents because they're homeless, but they have a phone and they're able to come to court that way. And they didn't have to figure out a bus pass or a way to pay for the bus. They didn't have to miss work for at least as long as they would have if they had to drive down here. They didn't have to get daycare for their child. So those are all things that district court does on a daily basis. And, you know, I think at times judges have been frustrated sometimes by Zoom appearances. It can lose somewhat of effectiveness sometimes, but I do think it's an important tool, and I'll always be an advocate to continue to use that tool when needed, because it provides better quality, in my opinion.
Thank you. Please describe a specific instance where you were faced with a difficult decision or a challenging situation that garnered significant public or professional scrutiny or pushback. How did you navigate that situation? What principles guided your actions, and what, if anything, would you do differently looking back?
I will say, as a supervisor at my office for the last 5 years, I've gotten a little more additional experience dealing with kind of difficult issues and having to be a decision maker sometimes on things. That can be, you know, issues with employees, attorneys that have come up where you have disclosures of concerns, whether that's their ability to do their job or some personal issues that are causing them not, you know, ability to be at work, having to assess that. And I think it's clear what's important is to have a good process in mind of how you're going to deal with those kind of issues. And that is one, you know, I think it's always important to do your, you know, a little investigation. You know, if something's reported to you, you take the report, but you also got to hear the other side, see if there's any other witnesses to the issue. I then usually consult with another senior attorney or my supervisor at the firm, certainly as well, and disclose the concerns. I've had to then call the ethics line to get through the Washington State Bar. I always really advocate my attorneys to use that when issues come up. Even when you've consulted with attorneys and attorneys are like, well, this is what you should do. I always add, because I'm usually the one being like, well, this is what I think you should do because they're coming to me. I always add, but follow up with the bar too as well. Let's always get as many opinions as possible. You know, I've had to be in the position as a supervisor to have really difficult conversations with people based on those concerns, based on the personal decisions. I've had to let go attorneys that have been with our office for a very long time. And then deal with the fallout, because we're a small community. So when things happen, it's noticed. In particular, those that work regularly in district court. So it's important to have that process where you're getting all the relevant information from different areas. You're following up and consulting with other senior attorneys. You're consulting with other experts, and for attorneys, it's the Washington State Bar. With judges, it would be the Code of Judicial Conduct and resources there. And then making sure you're making the best decision based on all those different resources. So I would say overall, that's, you know, how I go through those kind of difficult positions. And I feel it's really important in the end to be very transparent and as honest as possible when those things happen and a resolution has been made. We have 20 attorneys in our office and 5 support staff. And so when things happen, once again, just like it gets around the courtroom, it gets around the office. And, you know, they don't have the right necessarily to hear all the information that may be going on. But you also want to be as honest as possible as to, you know, what's happening and make sure that they know that you as a supervisor are there to reach out to and follow up with as needed. So those are the kind of the process I go through when dealing with those things. And, you know, it can be difficult. I just think really having that experience has been valuable to me. It's really hard to have some difficult conversations with some of our attorneys that had a really hard time with COVID and personal issues, and having to deal with that and be honest with them. And also, in the end, you have to protect the firm, the work, you know, as well, and the reputation of the office. And I think I would take that certainly to the bench.
Question number 5. Beyond your duties on the bench, how do you envision a district court judge actively contributing to the community and fostering public understanding and trust in the judicial system? Can you provide an example of your past involvement that demonstrates this commitment?
I do think the judges can have a role to certainly foster that respect of the justice system. I think it starts in your own courtroom, certainly, and I've touched on this, creating that atmosphere in the courtroom where people come into the courtroom, they are heard as much as possible, that as the judge, you're being that impartial decision maker, that you're making decisions that are clear, that are based on the law and based on the facts of the hand, but you're doing that with empathy for the people in your courtroom. So I think it starts certainly in your courtroom and creating the atmosphere there. You know, I think it's important when conducting trials. I think trials are very important to the justice system. You know, making sure that the parties that are going to trial, they have the time to prepare as needed, that you're taking that time to hear the pretrial motions and hear both sides, and making sure everyone's done what they need to do to create that fair trial. When you get to trial, taking that time to create an atmosphere in the courtroom where people can understand the importance of what they're doing as a juror, as a witness. And making sure, once again, that everyone has that time to be heard, I think is really important. In terms of outside the community, I do think it's important you are a community member. I see a judge, when you take that judicial role, you do need to take it seriously. So I do this with a lot of thought in the difference of the role of judge. And, you know, I think that, you know, there is going to be a difference in lifestyle for my personal lifestyle. I think there's a different way you need to hold yourself as a judge. And you know, I don't think my moral code certainly is going to change. But, you know, I am someone that understands that I can't go and, you know, make any political aspects known. I need to be very cognizant of how I'm presenting myself in the community, how I'm presenting myself on social media. I probably just get off social media. I'm barely on it anyways, to be honest. But, you know, I look to judges and how they interact in the community, and they can still take part, and they can still advocate for resources, and they can still make sure that the district court is a place to go for resources, and, you know, advocate for specialty courts and you know, how those work, how those operate, and how they can operate better. So I think those are ways judges can help with the community. Personally, I was on the board of the Clark County YWCA for 6 years. That was a great experience. That's, you know, they work with a lot of victims of crimes. So I don't know if a lot of defense attorneys would think to maybe go do that, but I thought it was really great experience. And I understand that actually anyone in the courtroom, defendants, victims, many of them are victims of domestic violence. So those resources have been important to many people that walk in the courtroom. And so it was a great experience. It gave me a lot of training, additional training on equity and diversity as well, that I wouldn't have gone just as an attorney. My children are active in school. They're 13, 11, and 5. So I'm very involved in their school district. My husband's an educator as well. So, you know, we're very involved in the community. The safety of the community is very important to me. So how I operate my day-to-day life will also be a reflection of how I want them to see me as a judge, and that I'm someone who is honest, transparent, and operate from a place that wants to make the right decision and be a good, productive member of the community. And that's really one of the reasons I want to participate in district court, because we have so many opportunities to do that.
All right, thank you, Megan. My next question is, what do you see as the unwritten responsibilities of a district court judge? How would you meet them if appointed?
That's a good question. I'm trying not to, I mean, I think I touched on it a bit. I think it's one, how you conduct yourself in all areas. I think two, it's being an advocate for those resources. I think one thing I would really try to do as a judge is to continually try to identify some of the gaps in services for court. And what I mean is there are always areas where we lose people. Sometimes after first appearance, you give a defendant, all these things to do. And you need to do this, this, and this, and you need to check in here and go do that. And they're stressed, they're flustered, they leave the courtroom, and it goes completely out of their brain. So there's always a good percentage of people that we are losing. And I think as a judge, it's important to be aware of that and to want to make sure throughout, your time on the bench, off the bench, that you are trying to identify those gaps and be an advocate to address some of those issues. I think our hope is with the new courthouse, we're going to have probation and pretrial right in the building, because I know it seems weird, but I lose defendants from leaving that building to coming over here and then we moved probation. So they were in the jail for years and now they were down here, and that created, a lot of confusion. So I think there are, that's one of those kind of unwritten things. I don't think it's requirement of a judge to, maybe care about those issues or make sure to continually highlight those issues, but I think it's important. I think, maintaining training when it's in terms of equity, diversity nowadays is really important. I think it's something you have to continually do, whether as an attorney or a judge. Once again, I think that helps create that empathy that's required in court. So I would also, highlight that. So I think there'll be things that I'm going to learn when I get there. I remember when I was my first job was Cowlitz County Probation. I was the front desk receptionist, and I would have clients, defendants come from court, and I would sign them up for all these cases. And I was thinking about going to law school, and I would see these people come in so confused, and I would judge these attorneys, be like, why aren't they with their client? Why don't they come into the courtroom? And then I became an attorney, and I realized, oh, you don't have time. You don't have time to do that. That's impossible. And so I know making this move to judge, there's going to be things that I'm just going to be like, you assume, and then you get on the bench and you're like, oh, no. This is reality, and there's some things I'm going to have to adjust. So I think definitely being open to those adjustments and being open to reaching out and receiving criticism and feedback as I get on the bench will be important, so I can understand, some of the things that I should know as responsibilities, but some of those unwritten responsibilities as well.
Thank you. My next question is, describe your personal decision-making process.
Well, I am someone, I would consider myself someone who's decisive. I am not afraid to make a decision. However, to get to that point, I do want to make sure that I have all the relevant information. So I think the most beneficial example of this would be, acting as a pro tem in Superior Court, just because when I did that, once again, it was an area that wasn't an area I practiced as an attorney. So it was really starting from ground zero, meaning that I had to learn the relevant law. I had to review, and in family law, the files can be hundreds of pages. So you can really go back years to see how and why you now are seeing this family again in court. So there's a lot to review. And then I am always telling my attorneys that I'm training, and I try to do it myself, please don't be afraid to ask questions. I get more concerned when an attorney doesn't ask me questions when they're starting out than if you are asking questions. It scares me if you're not asking questions and you're starting a new position like this. So really being comfortable on going and seeking assistance from other judges. I think it's really important to have a mentor when you start out in these kind of roles. So kind of having someone in particular that you can go to. And this process, I think, has shown me that there's, a lot of judges that are willing to assist with me on that. So I feel really comfortable with being able to do that. So I think those are all very important things. Ultimately, it's important for the judge. They are the final decision maker. That decision does need to be based on the law and the facts of the case. It needs to be impartial. You need to be aware of your personal biases. Everyone has them. We're all human with human experiences. But you need to understand your role as the judge and be comfortable making those difficult decisions and having those difficult conversations with people sometimes, because there's going to be one side generally is not going to be happy. So you have to be okay with that. And, my experience working with clients, and a lot of them are stressed, unhappy clients. I feel I'm really ready for that aspect of it.
Great. Here we are at the last question.
Was I too quick? Okay.
No, you were just right. Is there anything we have not discussed that you would like us to know when considering you for this position? And do you have any questions for us?
I just really feel passionate about this particular area of district court, of our community and district court. So I really, I've been doing this a long time. I really understand what I'm getting into. And I say that, while with excitement, with really aware of where district court's at right now and the stress of these huge dockets. I'm not going to go in naive to that. And there are still most days, right now I'm doing mostly work with juveniles and my civil commitments, but still supervising district court. So I'm still there most days. So I still have a very good understanding of what's going on there and what attorneys in the courts are dealing with, both prosecutor and defense wise. So, I would be really excited to get in there and do the work. I think on my letter to the bar, I had mentioned that I am someone that's really had to work, and I take pride in my work ethic. And I know I could really come in from day one and help the judges, commissioners that have been doing the work in district court, and really try to help alleviate some of this load for them, for the judicial assistants, from the clerks in the office, and for the attorneys. And in the hopes that creates a more efficient courtrooms where people get more opportunities to be heard, to have their cases reviewed, considered, and to get resolved in a timely manner. So, I really would stress that and say that I would be, honored and excited to get to this position. It's something I've thought about for a long time, and, put my name in at this point because I knew I was ready for that role. And then, I'm sorry, was there the second part of the question? Oh, questions for you. Is there anything about district court or defense-wise that you guys were wondering about or had questions about? while I'm here.
Well, maybe we can save that for another time.
Okay.
Let me just close by really thanking you
Yeah.
so much for your service to the community and for applying for this position. We are grateful to you for that. As this is a public process, we will continue the interviews and then we'll go into executive session for, I think, probably a fairly brief period to deliberate and then come back into open session and make our whatever decision we've arrived at the end of the day, probably around 3:00.
Okay.
If you want to come back or tune in, you'll be able to hear what we've decided. So thanks
Great.
again so much.
Thank you. I appreciate your time.
Thank you.
Well, and again, we have just a few minutes before our next candidate, if anyone needs a break.
Morning.
Good morning. Welcome. Please sit down and you can press the button there. The light turns green when it's going. So council is interviewing Colin Hayes for our two district court judge positions that are open. So welcome. Thank you very much for applying. We appreciate it. I just want to let you know that this is a public process. People are online listening and we have someone in the audience listening as well. So we have 8 questions to ask. We'll take turns asking and 45 minutes for the interview. So if you want to pace yourself, that would be great. And just for starters, we can introduce ourselves. I'm Sue Marshall. I chair the County Council, represent District 5, the northern half of Clark County.
I'm Counselor Young. I'm the west side of Vancouver, which is District 1.
Good morning. Will Fuentes, District 3, East Vancouver.
Michelle Belcott, Counselor District 2. It's Central Vancouver.
Nice to meet you all.
Great. So I'll start out with the first question. Given the description of this position, please tell us how your unique qualifications and experience make you the most suitable candidate for a district court judge and articulate your primary motivations for seeking this role.
Sure. So I'll address my primary motive.
I'm wondering if you need that a little bit closer to the mic, one way or the other.
Yeah, there's the microphone. I'll address my primary motivations first. I think this job would be fun, fulfilling, interesting, and I think I'd be really good at it. I think it's a good matchup for my skill set. I have loved my time on the bench thus far. Back when I was cutting my teeth as the municipal court judge for Elmer City and continuing on for the last year and a half while I've been doing civil dockets in district court as a pro tem judge and in Superior Court doing civil protection order dockets as well. I love that judges get to make a difference in people's day-to-day lives, not just in the outcome of the case, like how they rule at the end, but how they treat them and how they speak to them throughout that process. As a prosecutor, I know that for victims, judges' words are incredibly meaningful and stick, even if it's something that I, as a prosecutor, have been saying to a victim for months. When a judge says it to them, it like has a special impact and they carry that on forever with them. And that would be a really wonderful opportunity to have. And I like helping people. As a judge, you get to help people try to have the most positive interaction they're able to have with the court system, given the unpleasant circumstances that they're typically in, to make sure that they at least feel like they're getting heard, the rights are being respected, and they feel like they're being treated fair. Part of what judges do is they look out for community safety, both in the way that they pronounce sentences and the way that they set release conditions, and while still respecting everyone's rights. And I believe in that mission. That's the same thing I've been doing as a prosecutor my entire career. This job would never get old for me. Each day brings new people, new sets of facts, new decisions that have to be made. So even though you might be doing the same docket every day, it's not the same people, and it would continually be fresh and interesting for me. I also want to continue to learn, grow, and challenge myself. I've absolutely loved my time as a prosecutor for the last 22 years. I wouldn't trade it for anything, but I want to continue to grow and branch out, and this job would allow me to do that and accomplish those things. My calling is public service. I've been a public servant my whole career. I plan to be a public servant for the duration of it, and this position would allow me to do that just in a new capacity. Switching gears to why I think I'd be a good fit for this job, I have extensive trial experience. I've done 111 jury trials to verdict, as well as a few dozen bench trials on top of it. That is a much higher number than most attorneys I know. And having done that many trials comes along with that knowing the rules of evidence really well. There's a 600-page book that the attorneys and judges go by to determine what evidence should or shouldn't be coming in, and that's what judges are held to be applying. I've been a source of advice within our office for evidentiary issues as well. I've also encountered all the different things that can go wrong or need to be addressed during trial. So I would be very good to make sure that trials aren't going to have to be done over again, costing more time and money. I have appellate experience. I've been in our appeals unit for the last couple of years. For anyone who doesn't know what the appeals unit is, anytime someone gets convicted after trial, they are almost always filing an appeal. There's other ways that appeals can come into the system, but that's the primary way, and they'll raise issues about why they think their rights were violated or they weren't treated fairly either during trial or throughout the process, and our appeals unit responds to those and defends the convictions. So all that to say is I've basically been studying for years ways the judges can avoid getting reversed and avoid having to do trials over, and what judges should be doing in order to make sure that people's rights are being respected and everything's done the right way. I've also had a couple of years experience in therapeutic courts, of which there are several in district court, but I handled drug court, mental health court, treatment alternative court. Yeah, drug court, mental health court, veterans court. Yeah, all of those. So all the treatment courts and district court, I've been a prosecutor on for a couple of years. So I know how those work. I know the important usefulness of those programs. I also know what it takes for someone to get into recovery and the kind of mindset it takes, the hard work it takes. I know the different segments of the treatment programs and all that. So that would be incredibly helpful to a judge in figuring out the best way to help someone as they go forward after, at the time that they're sentenced. I have extensive training in domestic violence, sexual assault, child abuse. I handled many of those cases over my career, but to many trainings on those topics. So that would be really helpful as a judge when I am presiding over domestic violence petitions for protection orders, anything involving family violence or any criminal cases involving domestic violence, extensive experience understanding the cycle of violence, why victims stay in abusive relationships, and when they can finally turn the corner and why that might happen. I understand the importance of meeting people where they're at. All the people that come into district court have very diverse backgrounds, different incomes, different cultures, different upbringings, and judges have to be culturally sensitive, culturally competent, the way they deal with people, the way they speak to people, and be empathetic. And I have been dealt with thousands upon thousands of victims, witnesses, court participants over my years, and I've been able to do it with empathy and respect and explain the legal process in a way that's not condescending, but stays shy of giving legal advice, which prosecutors can't give and judges can't either. So that experience would be very helpful because there's a lot of unrepresented litigants in district court. I have I would say, a good temperament for being on the bench. I have a pretty calm, quiet demeanor. It's good for diffusing tension. I would consider myself to be emotionally intelligent. Judges have to do a lot of community safety analyses, a little bit as I alluded to, when they're setting release conditions and when they're sentencing people. No judge ever wants to release, if someone comes in a DUI, no judge ever wants to release someone and have them perhaps drive under the influence again and maybe take someone's life. No judge ever wants to release someone who's been accused of domestic violence and have that person go out and commit another crime of domestic violence, possibly even take that victim's life, which unfortunately has happened in our county. So I've had my entire career been analyzing community safety, making recommendations to the court, looking at the risk tools that exist for our domestic violence cases now, and making those kind of arguments to the court and taking the things into consideration while still recognizing that they're presumed innocent at that point. So making that balancing is challenging and important. And I've had a lot of background that'll help me do that as a judge. I've spent time on the bench, as I alluded to earlier. As I said, cutting my teeth as a municipal court judge. I sat over monthly infraction dockets for Elmer City where people were coming in, they're mad that they've gotten a ticket. They could have implications for their license if they were to get that ticket. So, the city had hired a judge because they were hoping to get income from these tickets. A judge isn't a rubber stamp, and they still have to make sure that there's due process and everyone's rights are respected. So that was interesting navigating that. But it was, just listening to people and dealing with all kinds of people was really eye-opening and great experience. And Superior Court, I've been presiding over quite a lot of protection order dockets where there's allegations of domestic violence, sexual abuse, serious stuff, oftentimes with family and kids involved, and having to sort through that. And those are heavy decisions that are important. In district court, I've had the chance to preside over every kind of civil docket there is. I haven't been able to do the infraction dockets or the criminal dockets simply because as a prosecutor, that would be a conflict. So they don't call me in for those, but I've done all the other ones. I've done dozens of small claims trials in district courts, which I would say is kind of the epitome of what district court's about. Two people coming in, they don't have lawyers. It's for some amount, 10,000 or less. And, contract disputes, landlord tenant stuff, everyday things. And it's really, really important to people. And sometimes people aren't leaving that court particularly happy, but, part of the job is to make them understand why I've reached the ruling I have, how I came to it. And so most of the time, people might not like my decision, but they understand how I got there and they feel like the process was fair. So I've had a lot of practice listening to people and being empathetic and helping them understand what's going on. I think that would be it for that question.
Thank you, Colin. Next question. Describe your direct experience with the specific dockets and functions of the district court, such as presiding over jury trials, protection orders, or various criminal and civil hearings. Now, based on this experience, what is one significant challenge or opportunity you foresee for the Clark County District Court in the next 5 years? And how would you, as a judge, propose to address it?
Opportunity for change, I would set. Okay. All right. Got it.
What is the one significant challenge or opportunity you foresee for the Clark County District Court in the next 5 years? And how would you, as a judge, propose to address it?
Sure. So regarding the first part where you're asking for my understanding of the different dockets, there's civil dockets, there's the name changing dockets, there's dockets where people are challenging the way that their car has been towed, the impound hearing dockets, protection order dockets, small claims pretrial dockets, small claims trials. There are many different criminal hearings. There's the virtual arraignment first appearance dockets, arraignment dockets, pretrial dockets, readiness dockets, jury trials. So I've spent a lot of time in district court, in multiple district courts across the state, spent years practicing. I'm highly familiar with all the criminal dockets. And as my time in pro tem, I've been able to serve on all of those civil dockets, as I mentioned before. So had a lot of practice doing those. If I were to get this position, one of the first things I would do is go collect the data from the administrative office of the courts on how our court is working. They keep all kinds of statistics on every court across the state, even on individual judges. And so they keep tabs on things like what's the life of a case? How long has the case been taking? Having grand ideas about how to change things is all well and good, but unless you have, data behind it to back it up, people are going to be kind of like, all right, well, maybe give us some information about why you think that's a great idea. So that would be one of the first things I would do is gather the data and see how we're stacking up to other counties in our state, especially ones that are of similar size to us. I do know that large dockets are an issue. A lot of court congestion are an ongoing issue here. And so I would want to look at what's the average life span of, our criminal cases. Is there a way that we could be making those move through quicker? One thing I would do as a judge is maybe emulate Judge Lewis in Superior Court, who is well known for pushing cases through and calling cases ready and really holding counsel from both sides' feet to the fire in terms of figuring out what are we doing here? This case has been going on a while. So that's one thing I would do is try to make sure that cases aren't just getting continued such that the dockets are getting more and more bloated as we go forward. Another thing I would do is probably periodically review our budget to make sure that we're being good stewards of the taxpayers' money, meeting with the district court administrator, things like that. So I don't have a silver bullet to solve any one particular problem as I sit here today, because like I say, I want to get in there and look at all the data and get some information behind the ideas that I'm going to set forth.
Thank you.
How do you ensure that every individual who appears in your courtroom, regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to justice?
There's a number of ways that judges can do that. and that I would do that first, making sure that people can understand what's actually happening in court, spoken language. If sometimes it's obvious if somebody needs an interpreter, sometimes it's not, and you kind of have to work through that to see how comfortable they, what's the best language for them to understand what's going on so they can really understand the proceedings. So figuring out whether they need an interpreter, and the courts provide those obviously. So making sure that they have what they need to hear and understand what's going on. And as I kind of talked about a little bit before, judges really need to understand the importance of meeting people where they're at, what backgrounds they come from, what they've been through in life, and that can all affect the way that people present, the way they're able to receive information, and the expectations that maybe we should have for them and what they're able to do in their day-to-day life. Can you repeat that question one more time? I'm sorry.
Sure, absolutely. How do you ensure that every individual who appears in your courtroom, regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to justice?
Another way is to appoint them counsel, or at least give them the opportunity to be appointed counsel so that they can have legal representation. And if they indicate they want to represent themselves, have a lengthy discussion to make sure they understand the implications of that kind of decision of going forward without an attorney. Judges need to be culturally competent, culturally sensitive, both as a prosecutor and as a county employee. I've gone through many trainings on cultural sensitivity. I also, as personal, believe it's an important thing to employ because it's part of being kind. So that is one thing they can do, is just be cognizant. It's part of meeting them where they're at. So being respectful, being compassionate, emotionally intelligent, understanding where they're coming from and how they might take your words. So, choosing your language carefully when you're speaking to people such that it's not misinterpreted or taken a certain way. But explaining the process, especially to self-represented litigants, again, in a way that's not giving legal advice, because you're not allowed to do that, but perhaps guiding them to community resources. For instance, the Northwest Justice Project has a website full of all kinds of forums and advice. You can direct people to there. The YWCA helps people with certain parts of the legal process. The Volunteer Lawyers Program in the county exists also to help people. So you can direct people to the information and the community resources that can help them with that. And as a judge, I would continue to make sure I'm educated on all the resources that are out there so that I can give that information to people as they come in. So in a nutshell, how you treat people and making sure they know what's going on and they have resources, if they be that an attorney or outside resources.
Great. And before we move on, you have excellent posture, but I need for you to eat that microphone a little bit more because I'm hard at hearing, so I'm struggling just a little bit.
Sure, I will do my best.
Thank you. That's much better for me. Next question. Please describe a specific instance where you were faced with a difficult decision or a challenging situation that garnered significant public or professional scrutiny and pushback. How did you navigate that situation? What principles guided your actions? And what, if anything, would you do differently looking back?
I can think of a couple things that might fit what this question is calling for. When I was in Lewis County, I was asked to charge a case by the elected prosecutor. And I will say not the currently elected prosecutor. The person I'm talking about is not prosecutor anymore. But he had asked me to charge a case that was on his radar. I don't remember exactly why, but he was particularly interested in it. I looked at it. Now, prosecutors cannot, they have ethical duties regarding charging cases. They cannot charge a case if they don't think it's something that they could reasonably prove at trial. And they couldn't charge a case if they don't think that it, if they're not sure if they did it, if it doesn't meet the law, or if they're not sure that it happened, or if they don't think they can prove it. And here I did not ethically think that I could charge this case. I don't recall for which reason. This was about 17 years ago. But my boss was asking me to do this. I didn't ethically think I could. So I shared that information with him and I told him, I don't think I can charge this case. He didn't give me too hard a time. I think he knew he was pushing the envelope, but he found another prosecutor who did feel that they could charge it. So that was one ethical situation that I found myself in. The other thing comes to mind in having worked in the child abuse cases for a little over 10 years, you get a lot of families that have obviously very big feelings about what they want to see happen with a case. And a lot of times we don't file cases, even though we might think that something has happened, just because we don't think that we're going to be able to prove it. And having those conversations with families is incredibly difficult and can be tense. And it's kind of like a skill you develop. And at the end of those conversations, even though they didn't like my decision, 95% of the time, we still were leaving on good enough terms. They understand why I was making the decision, the constraints that I was under. So, and oftentimes they would be very upset during those conversations. This happens so often that it's hard for me to pinpoint any one particular time because it was, it's happening with such frequency and regularity. But that's what I would think of making those difficult decisions of, as a prosecutor, there's community safety on one hand. You don't want to put a victim through something if you don't think there's going to be a reason for doing it. In other words, if you don't think this case is actually going to be able to be proven, then you don't want to put that family through it. So there's a lot of competing considerations, community safety considerations, especially if you think, well, I believe this happened, but we're not going to be able to prove that to a jury of 12 people who don't know anything about these people or these background of these individuals. So that's what I would say in that regard.
Thank you. Question number 5. Beyond your duties on the bench, how do you envision a district court judge actively contributing to the community and fostering public understanding and trust in the judicial system? Please provide an example of your past involvement and demonstrates this commitment.
Well, judges, of course, need to be transparent, and everything needs to be done on the record so that it's open to public scrutiny. To make sure that the court is running well and serving the community as best it can. If I was in this position, I would forge individual relationships with all the stakeholders, all the people involved, the head of the Office of Assigned Counsel, head of the prosecutor's office, head of some of the police chiefs, obviously the head of district court administration, such that I can keep a finger on the pulse of what the issues are with district court, what's working well, what's not, and addressing things that are going on. And especially keeping track of what the public perceptions are. We may be doing everything correctly and the way it should be done, but if people aren't having a good perception of it, that's still a problem. That's something that we need to address nonetheless. So keeping a finger on the pulse so that we know what the public perceptions are, and course correcting as needed to help make sure that the public has the utmost trust in the way we're doing things. As these are important decisions that affect people's lives, and we need to make sure that the public has confidence in the way that we're doing it, such that we're respecting people's rights. So I would, on the smallest level, make sure I'm being respectful, transparent, and respecting people's rights that come through the court, but also meeting with all the stakeholders periodically on an individual basis. I'm pretty personable. I've visited. I have a good time knocking people's walls down, and so I can usually forge good individual friendships like that. So just getting involved with other people so that you know what's going on.
Thank you. Colin, my question is, what do you see as the unwritten responsibilities of a district court judge? How would you meet them if appointed?
Sure. One of the unwritten responsibilities is to be a good steward of taxpayer dollars. Even though the judges don't specifically set the budget per se, that would be the job of the counselors. They are still in charge of the money that is allotted. So making sure you're being reasonable and respectful of that money. And as I kind of said before, I would periodically want to review with our administrator, how we're spending the dollars and making sure we're doing that reasonably and being efficient. Another responsibility is just to be ethical, fair, obviously. Maybe those are written down in many rules, but it's still implied that you're going to be fair and treat everyone with kindness, respect, regardless of their background. you do have to be a team player. You're not the only elected judge. You're all working together as a team. And so you're not just an army of one. You're working with a lot of other people, the court staff, the other judges, court administrators. And so you need to get along with everyone, and that I'm a good team player. I do work well with others. I'm pretty easygoing, so that wouldn't be a problem. And make sure that the court's running efficiently, that dockets aren't getting too large, that they're not going, that you're not requiring court staff to work, through their lunch, things like that, as most as you can avoid. So you're still being efficient with the way you run things. And just being transparent and open with the public as you are a public elected official.
All right. Question number 7. Describe your personal decision-making process.
Well, when it comes to the law, it's somewhat straightforward in that you have the law and you have the facts and you apply to a lot of those facts. Kind of to delve into that a little bit deeper. In law school, they call it thinking like a lawyer, which took me the longest. I didn't know what that meant for the longest time, but really what they're saying is just taking the emotion out of it, just looking at it. Do these facts match up with this law, regardless of how you personally feel about it, the people involved, that kind of thing. What's the law? What's the application of the law to these facts? If we're talking about non-legal questions, and personally, it's a balancing of pros and cons is probably most anyone goes through of the decisions I make. What are the ramifications of this decision? What's the effect on other people going to be? And balancing that and trying to make the best choice that you can.
Okay, that brings us around to the last question. And that is there anything we've not discussed today that you would like to share with us? And do you have any questions for us?
Just a few other things that, I don't know, might be helpful for you to know. When I was working in Lewis County, I was the president of the board of directors of a group that was trying to get together kind of like what we have with the Children's Justice Center now, trying to get one of those there. Like at the time, no police department had any way to record child interviews, which is kind of the standard now. So worked for years gathering people and partners in the community, trying to get everyone together on board to create a nonprofit to make that. And after I left, it eventually did get 401. It did get the status of a nonprofit. So that was a very cool thing to be a part of. That was in addition to my normal duties as a prosecutor. I don't know if I hit on this very much, but I have a lot of management experience as well. I was the lead attorney in the Children's Justice Center unit of our office for a little over 4 years. That's supervising the attorneys, the victim advocates, the staff, as well as being a liaison to the Vancouver Police Department and Sheriff's Office, who are all housed there together. So, and during that time, I went through a few different county trainings on just being a good manager. I also was able to manage the district court unit in Lewis County when I was there for a period of time. So being in a management position is something I'm comfortable with, and I like to think that I'm good at it. As far as questions, I feel like I understand the job pretty well. Kind of the questions I have are, what are your timelines for your decision making, and what are some expected start dates, things of that nature?
I'm not sure about the start date, but as far as this process goes, we will be having 3 more interviews this afternoon. Then the council will go into executive session where we will confer with each other and then come back into a public session where if there's any action to be taken, it'll be taken then. That'll be around 3:00 this afternoon. So if you wanted to tune in or come back, you would be able to hear what we've decided. But as far as transitioning into the job, I don't have any details on that.
That's understandable.
Okay. Thank you very much for your service to the community. We really appreciate it. Really appreciate you coming in and applying for this position.
Thank you.
Thanks.
I also, I don't know if you all had a chance to look at them, as I know you had a lot of paperwork. I did bring copies in of my letters of recommendation. If that would be helpful for you all now, I can leave that. Okay. I'm getting some head nods, so I will leave those.
Great. All right. Have a good afternoon.
Thank you.
Okay, that brings us around to our lunch break, and we will reconvene at 12:30. So thanks, everyone. Okay, council has reconvened for our next interview for district court judge. Will you call our next person in?
Did you like the pizza?
Yeah, it was good.
It was good pizza. They have good pizza.
Do they? I got some chicken and. Hello and welcome. Our next interviewee is Greg Cheney. Thanks for being here. We appreciate taking the time to apply for the position. You can just hit the button and it'll turn green, and please don't be intimidated by the microphone. So just a few opening remarks here. This is a public process, so there are people likely online that are listening. And I think maybe just we'll take a moment to introduce ourselves. I'm Sue Marshall. I chair the council and represent District 5, the northern half of Clark County.
Counselor Young, District 1, which is the west side of 205 in the city of Vancouver.
Well, Fuentes, District 3, East Vancouver.
Oh, we don't have Michelle. Michelle Belcott represents District 2. She'll be joining us momentarily. Okay, so we have a 45-minute interview here, and we have 8 questions, so you can kind of pace yourself as we go along. And I'll start with the first question right here. So given the description of this position, please tell us how your unique qualifications and experience make you the most suitable candidate for district court judge, and articulate your primary motives for seeking this particular role.
Well, thank you for that question. First of all, let me just say thank you to all of you for having me here for an interview today. I very much appreciate it, and I'm very humbled to be able to have this opportunity. So I think the unique qualifications is having served over 3,000 individuals, primarily in Clark and Skamania County as part of indigent defense. I have a broad perspective on how courts operate, how to deal with clients on a daily basis, and how to improve our outcomes in the court system, both from an operational efficiency and also for particularly for those individuals involved. The primary motivator for me is mental health. I've talked about that in the past. I served on the NAMI Southwest Washington board for several years, but it is a very much a motivating factor for why I engage in this work. Mental health is something that I think affects all of us. Either we have seen it from friends or family, or even closer than that in some cases. And so I spend a lot of time thinking about how I can help individuals in the court system who are obviously struggling with mental health challenges. How do we improve outcomes for them? Because if we can help them get on the right track, either through medication or through court intervention, it would obviously lead to a reduce in repetitive criminal behavior. And that's the ultimate goal in keeping the community safe.
Thank you.
Thank you. Describe your direct experience with the specific dockets and functions of the district court. such as presiding over jury trials, protection orders, or various criminal and civil hearings. Now, based on this experience, what is one significant challenge or opportunity you foresee for the Clark County District Court in the next 5 years? And how would you, as a judge, propose to address it?
Well, thank you for that question. I think in terms of dockets, between Clark County, Battleground, and Skamania County, I'm in court about 4 days a week, if not 5 days a week. And so it's given me a broad opportunity to see how courts are operating in slightly different ways. Clark County, obviously, Battleground having dockets, and each of those court systems does things a little different. And so having that opportunity to be in each of those, I've handled multiple anti-harassment hearings. I've handled jury trials. I've handled bench trials, motion practice. I should also add that I am routinely in Superior Court on all of those matters as well. And so I think that gives me a broad perspective on how different courts do things and how we can learn from each one of them. Because I think that challenge for the Clark County District Court over the next few years is we are going to be entering into what I perceive as a real budgetary shortfall. I think there are grant programs both by the state and the federal government that are likely to taper off or at least be reduced in the next few years due to budgetary constraints. And so the question will be for the bench is how do we respond to that by ensuring not only that constitutional rights are protected for the parties involved, but also how do we deliver more efficient operations than we are right now? And so I'll give an example of that. One of the things that Tacoma and Pierce County courts, I think, do very well is when you are released from jail and the judge says, you know, you need to go check in with pretrial probation or post-trial conviction probation services. For that person that is getting out, they may have nothing. They may not have food. They may not have clothing, none of that. There is a food bank and a clothing bank donated by the community working with nonprofits right there in the probation services building. And so I spent a lot of time thinking about that. If I was a person just getting out of jail with nothing and I had nowhere to go and nowhere to turn to get even clothing, what is going to cause me to go engage in new criminal behavior? Probably desperation. So if we can work with our community partners to try to stave off that desperation even for a day, that could help that person and the community have less crime if we move forward in that direction. And so it's these type of operational efficiencies that I think we have to be very attentive to, particularly in a time where I foresee a budgetary reduction coming, and then being able to, of course, deliver on the constitutional rights that people deserve when they're in front of the court. I'll give another example of this efficiency that I think is a big, big challenge coming. As all of you know, the indigent defense standards were recently reduced by the Supreme Court. So instead of having 1 or 2 attorneys in front of the court, we are likely to have 3, 4, 5 attorneys doing that 1 to 2 attorneys job going into the future. So that means more people waiting. So right now, for example, Clark County has 8:30 and 10 a.m. court dockets. Well, is there a way we could break up that so we have less waiting time? Maybe 8:30, 9:30, and 10:30 so that we can give those attorneys, because there's going to be more attorneys in the courtroom, a chance to move between courtrooms more efficiently. That's one of the things that we've seen a little more flexibility in other courts that I practiced, and I think it would be an interesting thing to do so that we don't have attorneys and clients sitting around waiting for long periods of time. Again, time is money when it comes to court operations, and figuring out how to make sure we can do that efficiently, I think is a critical challenge going into the future.
Thank you.
How do you ensure that every individual who appears in your courtroom, regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to justice?
Sure. So that's a great question. I think, as I mentioned, I've represented thousands of clients. And when they come to me for help, I don't question what their background is or what their socioeconomic status is. My job is to help them, regardless of where they come from in life. And so part of that means listening and being respectful to them, even when it may seem like it's taking more time than it should. Stopping, listening. And I think a lot about the listening challenge quite a bit, because within the context of mental health and particularly neurodiversity. So oftentimes there's a tendency, just a human nature, when somebody's not understanding you, if you're talking to them, to get very frustrated and maybe raise your voice. Well, if somebody is neurologically divergent or comes from a different background where different communication methods are used, I spend a lot of time thinking about how do I get the message through to that person, while also being aware that the communication method may not be the problem here. They may not be hearing what I'm saying, not through their own fault, but because they have a different background or a different way of thinking or a different neurodivergent path. And so that is the type of thing that I think about with my clients. And it would be no different when I'm on the bench. When I think about how do I reach someone, I want them to come away that they feel respected and heard. And that is even if I am going to rule against them on something, I want that person to know that they had a fair shake, they had a fair shot. And part of that is listening quietly, spending more time in communication and conversation to them so that you really understand how they're hearing you and what they are hearing, and then listening back to what they're saying, either to an attorney or on the bench.
Please describe a specific instance where you were faced with a difficult decision or a challenging situation that garnered significant public or professional scrutiny and pushback. How did you navigate that situation? What principles guided your actions? And what, if anything, would you do differently looking back?
Well, I think that we're all challenged all the time, but I'll give an example. I handle on contract for Clark County a number of Involuntary Treatment Act cases. Those are the cases where someone is hospitalized against their will because they're a danger to either themselves or to others. And so oftentimes those folks are in an active state of schizophrenia or paranoid delusion. Their medication hasn't yet worked or isn't yet caught up. And so part of what is very challenging for me is there may be an obvious answer, which is, well, of course you should stay in the hospital and get the help you need. But it's not about what I think is efficient or what I think is reasonable. It's can you reach that person in the mental state that they're at for that active delusion that they might be under. And so I wonder on a regular basis, am I communicating with them properly that they can understand? And if I can't get through to them, is there a way that I could be better presenting at least my demeanor that will help them calm? So in a particular case that I'm thinking of, the individual was actively psychotic, having challenges with the staff. And it was clear that no matter what I was trying to convey or communicate to them, they were not able to hear it because of the state they were in. And so what I tried to do is just kind of sit back with an attentive look on my face so that they knew that whatever they were saying, even if it was delusional, it was being listened to or heard to. Try to kind of like a steam valve, you're releasing the steam on a person. And so I don't know if that was legally the right way to handle it. But what I know is over the 10 minutes or so or 15 minutes that I just kind of listened to them, they were able to calm themselves down to a point where at least, even though they were having a challenge, they weren't going to actively hurt themselves, me, or another employee there at the facility, and just listening to them. And it is, it's always important, I think, to take that attitude with folks. Just being there can sometimes be enough. And it's not a matter of whether or not it's the legal perfect answer. It's a matter of the attitude in which you're showing to the person, which is that attentive, listening, thoughtful, compassion, doing that. Again, there might be other ways to handle that situation, but I think of deflating those type of situations is usually the most benefit for everyone involved. I'll give a slightly different example of a case that was a challenge. I handled a case for over 3 years, a civil litigation matter. And when you live with a civil litigation matter, they can take numerous twists and turns through the appellate court systems. And oftentimes you have a client who within the civil system is suing for a breach of contract or something like that. They're very unsure. They usually haven't been sued before. They haven't had to file a lawsuit before. And how do you keep that client explaining the processes and steps you go through? And, you know, I made a suggestion that an appeal be pursued. The client ultimately didn't want to do that. But again, I think that making sure that the client understands where you're going, where you're headed, why you're making the recommendations that you are, I think are all transferable to being a judge. And that is, again, making sure that you're being clear about what the expectations are from a client appearing in front of you or an attorney appearing in front of you, being clear with what the next steps are in a case might be to someone who's never been involved in the court system and how you handle that. And that is the type of education piece that I try to do with all of my clients. Here's the forecast. Here's how much time an average case will take in Clark, Battleground, Skamania County. Here's where there might be motion practice. Well, what does a motion mean? How does that affect the court system? And making sure that there's a level of education so that the person, either as an attorney or as a judge appearing in front of me, has a basic understanding of what is happening in front of them, as that could be a very scary thing that we should not take for granted, in my view, is that anyone has ever explained to them before.
Thank you. Question number 5, beyond your duties on the bench, how do you envision a district court judge actively contributing to the community and fostering public understanding and trust in the judicial system? Now, can you provide an example of your past involvement that demonstrates this commitment?
Sure. Several years ago, I served for a few years on the Clark County Bar Association, served there as treasurer. It was very involved in bar events. I think it's a good organization that can promote and help educate, as well as be a resource, particularly to pro se clients who don't know where to turn, about where resources are to help them in the system. For those similar reasons, I also worked on NAMI, or served on the board of NAMI Southwest Washington, because I deeply believe in helping reaching people with mental health challenges. And oftentimes I find in my practice that substance abuse is right alongside usually with mental health. It's a little bit of, did the chicken or the egg come first sometimes? Is the person self-medicating for a mental health, or did they use a substance first that changed permanently the brain pathways that have now led to that mental health challenge? And so thinking through those issues and trying to advocate for better access to services. I also spent a significant amount of time in the legislature working on those issues, again, both substance abuse and mental health, and trying to ensure that folks' rights are both being protected, but also to make sure that there are conduits for getting access to those treatment. I fear right now that we have a significant roadblock towards getting access to those treatments. And I'll give a very concrete example to that. Councilor Marshall, you know that if you're in North Clark County, there is limited bus services to some of those areas. So if you are from the bench ordering a person to engage in treatment services, but they have no driver's license because it's suspended, there's no bus stop around, they can't get to a bus stop, they don't have family or friends available, how does that person actually engage in treatment services if they don't have a way to get there? And so thinking through both as an attorney and what I'm advocating for a person, but also thinking through from the perspective of a judge, if I want them to get these treatment services, how can working with a probation or working with their attorney, we actually get them to these appointments? Does that mean having a little leeway so that we can get them to a treatment provider that can take an appointment on Zoom, for example, rather than making them try to, break the law again by driving illegally without a driver's license or without that bus service? And so, again, I spent a lot of time thinking through these issues because what I want to make sure of is, as a judge, if I'm going to sentence a person to a certain requirements, that they have the ability to do that. And if they don't, is there things that we can do from the bench or the probation department or even from our partners in the community to help them achieve those goals? And can you repeat the last part of your question?
Can you provide an example of your past involvement that demonstrates this commitment? Yeah, you did mention the Clark County Bar Association, and you have a couple more listed on your.
Yeah. And so the other thing I did in the legislature, and I won't dwell on that, I think that most of you know I was there, but one of the things that I was able to serve on is the joint state Supreme Court and House and Senate joint committee called the Interagency Committee, a generic government name. But what the purpose of that was to think through court operations, from how do we develop policy around those, both in terms of operations, but also budgetary priorities for the court system, and working with, there is not only state senators, state representatives on there, state Supreme Court, but also municipal judges, Superior Court judges, and Court of Appeal judges, looking systemically, how do we make sure that the court system is operating? What are its needs? What are the budgetary constraints? And I found that greatly a great opportunity that I immensely enjoyed, because it isn't just about how Clark County District Court might be operating, but how Pierce County might be operating, how the Court of Appeals Division 2 is operating, and then how those experiences, having worked in 3 different courts for the last 10 to 12 years now, how do those play into how do we improve efficiencies within the Clark County District Court system as we move forward in what I anticipate is a tough budgetary environment?
Great, thank you. That goes on to question 6. What do you see as the unwritten responsibilities of a district court judge? How would you meet them if appointed?
I want to make sure I heard that right, Counselor. Unwritten responsibilities?
Correct.
Okay. I'm not sure what an unwritten responsibility is, but I presume that it means taking your job seriously, doing so without conflict or without prejudice. Certainly, I think that everybody comes at it from a different perspective, but I would certainly want to make sure that anyone appearing in front of my court knows that they have a fair shot, that they have a fair opportunity, that there's no conflict either in my past or in my family or spouse or anything like that that would create an appearance of unfairness to that individual appearing in front of me in the court. And so I would want to make sure that I'm deeply respectful of each person, deeply respectful of my colleagues on the bench, both the prosecutors and defenders, as well as the clients, and making sure that they know that they're getting a fair shot without any prejudice or any bias. And really feeling, again, like they are heard and treated fairly when they're in front of me.
Thank you. Question 7, please describe your personal decision-making process.
Well, I tend not to like making snap decisions. Generally, the way I treat a decision is by thoroughly thinking through, researching the options, consulting with people that I trust, and then coming to the most reasoned decision that I can. Whether or not it's right or wrong isn't necessarily as important to me as trying to do the right thing for the right reason. After that research and, if necessary, talking to colleagues about it. And so how I would envision that as a judge, or certainly it has played out this way as an attorney, is that I spend a lot of time in the pretrial phase of a case. That is interviewing witnesses, researching legal issues, figuring out if there's motions to be made, working through those issues, and then going to the prosecutor when I'm done with that and saying, here's what my perspective is on this case after having spoken with my client. Are you willing to negotiate on this point or that point? And or do we need to go to trial? And doing it with a respectful attitude. I don't necessarily expect a prosecutor to agree with me, but I want to make sure that they know that I'm coming from a well-informed, well-reasoned position, not a snap judgment on something. And so as a judge, I would anticipate doing a significant amount of research to make sure I understand the history of the cases that are coming in front of me, what has been pled, what's already in the file, and then listening attentively to the prosecutor and the defense attorney as to where the case is, what the position of the case is, and then making that decision. And so, again, it's a very I don't tend to make quick decisions, but I do think that I try to make informed decisions. And so for me, the way I would inform myself is before the clients are ever in front of me on the docket, I want to spend enough time in the files of each of those cases for that morning. You know, if it means getting here earlier or later at night, staying so I can prepare for the next day rather than just simply opening the file for the first time when it's in front of me on the bench, so that I can be ready and informed and then able to make what might appear to be a quick decision. So we're not holding people in the courtroom longer than necessary, but it is a well-informed decision based upon that prior research in combination with what the defense attorneys have said a few moments ago, or the prosecutor.
Okay, that brings us to the last question. And that is there anything we have not discussed that you would like us to know when we're considering you for this position? And do you have any questions for us?
Well, again, I'll go back to what I started with, which is it's such an honor to even be considered for this position. And so thank you all for having this interview. You know, I think for those of us who go into public defense, we don't do it to get rich. I know that's certainly my case. I didn't intend to get rich in this, and that's okay. But I think it's the combination of trying to help people where they're at, try to get a better outcome for those individuals, And then also trying to, as best I can, stand up for the rule of law, stand up for the constitutional rights of everyone, regardless of race or creed or background or socioeconomic group. And I think those things are critically important to being a judge as well. As I mentioned, I've handled thousands of cases in my career spanning over 10 years. I have civil, that includes civil, criminal, felonies, criminal misdemeanors, as well as Involuntary Treatment Act cases. And that has given me as well as working in 3 different courthouses primarily, it's given me a very broad perspective on listening to what judges who I respect are doing. How am I learning from them? And how does that, if I were to be on the bench, how does that affect and influence the way I'm thinking about decision making from the bench? And so it's that learning experience of having a tremendous amount of experience before different judges with different personalities to figure out what works for me and how would I best show people that they, regardless of who they are, they have a fair shot. And that includes prosecutors as well. Making sure that the prosecutor is heard, making sure that the individual is heard. And then, if necessary, being able to make a ruling and then move forward from that ruling and balancing the requirements that we need to obviously protect society in some cases from certain individuals. That could include jail. But if we're not looking at jail options, how do we make sure that we're not setting someone up to failure? Like I talked about with the bus passes, how do we make sure that we're not setting up this person to failure? Well, if what we actually want them to do is get the treatment they need so they never commit a new crime. And so over the years, I spent a lot of time thinking about that. And it's that background that I think I know I'm very interested in being a judge to try to figure out how to bridge that gap from what we're doing when the prosecutor orders them to get mental health, substance abuse treatment, but they don't have that bus pass, they don't have that driver's license. How can we actually set up that person to succeed rather than fail in the future? Finally, I just add that having grown up and lived here most of my life, it is not a small thing to having represented folks, for example, who I went to high school with occasionally. And I think that goes to the broader community. In other words, we are here to serve our communities. We're here to do justice for our communities. It's not about whether or not a defense attorney or prosecutor is making a bunch of money at their job. Usually they're not. But it is about trying to do the right thing for the community in which we live in. And that would be ultimately my ultimate goal in becoming a judge, is to try to do those right things by the community in which we reside. Thank you.
Great. And did you have any questions for us at this time?
The only obvious question is, obviously there'll be a decision made at some point. Is there a timeline for making that decision, or what is the expectation?
Thanks. I was going to get to that. So this is a public process. We have a couple more interviews. Following the interviews, we'll go into an executive session. The council will have some discussion amongst ourselves. We'll come back before the public and take action at that point. So we could know around 3 o'clock.
Oh.
You're welcome to either come back or tune in. This is online. So we'll know something around 3 o'clock.
Well, you are a very quick governmental decision entity if you'll know something by 3 o'clock. That's pretty good efficiency.
Thank you. And I do just want to take a moment to thank you very much, Greg, for all of this service that you've provided to the community.
Thank you.
We are very grateful for you coming in and applying for this position.
Great. Thank you.
Thank you. I think that concludes this interview, and we appreciate being told where we make decisions. We'll take that to heart. So we have a few minutes. We have about 10 minutes before the next interview. So have a good afternoon. Uh-huh. Okay, so welcome. Our next interview is Ryan Busby. So welcome. Happy to have you here. Thank you very much for applying. We'll start out with just some introductions of ourselves. I'm Sue Marshall. I chair the county council and represent District 5, the northern half of the county.
I'm Counselor Young in District 1, which is Vancouver, the west side of I-205.
Councillor Will Fuentes, District 3, East Vancouver.
Michelle Belcott, District 2, Central Vancouver.
Okay, so just to let you know a little how this process will unfold, this is a public process. So there are people online who are observing, and we have about 45 minutes and 8 questions that we'll be asking you. So you can pace yourself as we go through there. I guess with that, I'll just go ahead and ask the first question, which is, given the description of this position, please tell us how your unique qualifications and experience makes you the most suitable candidate for a district court judge, and articulate your primary motivations for seeking this particular role.
Thank you. So my practice has been fairly varied. I've practiced in a number of jurisdictions, including Oregon, Washington. I've practiced in a number of counties all throughout Southwest Washington. So I've seen a lot of different court systems, different procedures. I've appeared as a criminal defense attorney in district court in Cowlitz, Clark, Skamania, Wahkiakum County, done a little in Lewis County. I've prosecuted for 4 different municipalities, Battleground, Ridgefield, and La Center. I was filled in for about 3 months as their full-time prosecutor. And then I have been their conflict prosecutor for the last 3 years now. And so I've seen from both sides. I've also prosecuted as a fill-in for City of Longview when one of their prosecutors was on maternity leave. And so I've seen from both sides of the criminal spectrum. I've also done a significant amount of civil work, and I've filled in as a plaintiff's attorney and a civil defense attorney, defending civil no contact orders, and even some less common practices. I've done a writ of replevin, which is a nice district court, kind of a unusual lawsuit. I've also pro tem'd for the last 3 years. I've been one of the few pro tems that has actually been able to sit in every docket that district court here in Clark County has pro tem coverage for. So I've done civil infractions. I've done all of the criminal dockets, probation violation dockets, changes of plea. I've done small claims trials as a pro tem. I've done the civil no contact order. I've filled in and done some ex parte for the court as well when they've needed a conflict, judge pro tem, because there's a conflict in the court. They've asked me to review documents before the court proceedings. And so I've done that. I've stepped in and helped the court with those things. And so my experience is a nice wide variety. I haven't pigeonholed myself into one area of practice. I worked for a general practice firm up in Longview for about 4 years. And as the low man on the totem pole there, when I joined, it was take any case that comes in the door. If the partners don't want it, it came to me. And so it's allowed me to practice land use, to practice disputes between neighbors, disputes between landlord-tenant, involving both Superior Court and District Court when they're suing for small portions of money. And so that experience, I think, amongst the candidates, I believe is unique in that I have seen every role in District Court multiple times. I have done bench trials, I've done jury trials, and I've been a public defender as well. My primary practice now is juvenile dependency, representing parents, and I have been doing that for approximately 8 years. And so it's all court-appointed work. And so I've worked with folks throughout our community that have been marginalized, seen the impacts that the process can have on folks who don't have necessarily the means to hire an attorney, and the difficulties and struggles that they have. I've also done private retained work, and while the job stays the same, there are different aspects when you are representing an individual who needs appointed counsel versus someone who's paying their own bill. And so we see different iterations of the court process, and I think that that's given me a great perspective. As for the why, I have my practice, I've always given advice, and I think the dependency world in particular, these are appointed clients that stay with you for 2, 3, sometimes 4 years, whereas the typical criminal appointed client, you'll have maybe a couple of years on a serious felony, but your involvement with them isn't going to be every other week necessarily in preparing for that case and being directly involved with them. And so I have found that I am required in my job to provide that counsel portion of the legal profession, where we give advice, we give counsel to our clients. And I always approach my clients with a perspective of, let's look at both sides. How do I see the strengths of my case and the weaknesses in my case, and then also look at the other side and say, here are the strengths and weaknesses from the opposing counsel. This is what they're going to need to do, and how would the judge most likely rule on this? And that determines strategy that I make my recommendations. Now, as an attorney, we represent our client, and so our strategy doesn't necessarily control, and we have to be able to adapt and represent our clients. And I've always approached it the best way is to be the most reasonable person in the room, try and get to the correct result, what I think is most likely going to be the outcome, and give that advice. Now, it doesn't necessarily mean that's how I'm going to have to argue for my client, but it is what a judge is supposed to do, which is look at both sides, take the information that comes in, and make the most correct decision that you can. And so I have found that my skill set, I think, lends itself to the judiciary. That has been where I have felt the most complete in my service. So when I've been pro temping, I feel like I have a good demeanor on the bench, and I can sit and listen to both sides. And whether I agree necessarily personally doesn't matter. It is listen to the story that comes in, listen to the facts that are presented, find out what the law requires, and then enforce that while making sure that everybody feels heard and respected in the courtroom. And so it really feels like a calling to me that this is where my skills lend themselves, because it's how I've approached my legal practice as an attorney, is trying to determine what would the judge likely decide, and how do I either improve upon that for my client or become the most reasonable so that the court will agree with me. That's the part of counsel. So that's why.
Thank you.
Thank you. Question number 2. Describe your direct experience with the specific dockets and functions of the district court, such as presiding over jury trials, protection orders, or various criminal and civil hearings. Now, based on this experience, what is one significant challenge or opportunity you foresee for the Clark County District Court in the next 5 years, and how would you, if selected to become a judge, propose to address it?
Thank you. I believe I may have touched on this a bit. I have presided over a number of dockets. I have been one of, I think, the go-to pro tems for Clark County District Court. As I said, I've presided over every district court criminal docket that is available for pro tems. I've done all of the civil dockets, infractions, both in front of pro se litigants and represented parties. I've done small claims trials, which I think are probably one of the more interesting matters that come in front of the court, because you have to deal with random legal issues that come up. And sometimes they're unfamiliar, and it's you have to prepare beforehand, which is a pro tem that can be difficult because it's not my full-time job. But I've always made it a point when I'm covering small claims to come in and prepare beforehand, make sure I've reviewed all the exhibits, make sure I've reviewed all the pleadings beforehand. The interesting thing with small claims is it's also a pro se, attorneys aren't allowed. So you're dealing with members of the community directly, members who don't have the training but are still required to follow rules of evidence in presenting their case, and may not know what rights they are giving up. I had one case in particular sticks out to me, in which it was very clear from reading through the pleadings that the petitioner wanted relief that was not possible for me to give. And I was very clear at the outset that in reading through your pleadings, it looks like you're looking for the return of property, but small claims can only award money. So I can't award a return of your property. There are other aspects and other lawsuits you could file to have that return of property. But if you go forward today, you are going to be waiving those. And so it was very important for me to, while not giving advice, at least advise on the process and the rights that our litigants are potentially waiving by proceeding. And so it's important when dealing with, especially district court, we have a lot more pro se folks coming in because it is the people's court. It is the first time that people are dealing with the court systems frequently. As an attorney that's taken private cases, there's been times where the attorney's fees outweigh the recovery these people are trying to receive. And so it's difficult for these folks. They're no less important issues. And so I have overseen most of the dockets. I have gone through jury trials. I've gone through bench trials as an attorney, as both defense and prosecution, as both civil and civil defense and civil plaintiffs. And so I have a lot of direct experience in all aspects of district court. One of the significant challenges I think the court is facing in the next 5 years is, as you're aware, the appointed counsel, we're having a shortage of appointed counsel and attorneys that are available to do that. And I think that's going to continue to be a problem. Across the river, we're seeing cases being dismissed because folks cannot be deprived of their constitutional right to counsel. And if there's not enough attorneys to appoint, that leaves the court with little to no options in times. And that's not good for our community to have criminal cases that should be prosecuted potentially being dismissed simply because we do not have the attorneys to represent these folks. And so I think the way that a judge can address that is by working with our stakeholders, working with counsel regarding funding issues, working with law enforcement, the jail staff, working with the prosecuting attorney's office, as well as our new appointed counsel, criminal defense office, as well as the general criminal defense bar. Having those folks meet together, provide what do we need? What is it that's preventing the local attorneys from taking contracts? If that's the route we're still going, what do we need to move things into the criminal defense office? Those types of things. And that's important for the judges. We can't solve the problem ourselves, but we have to work together with all of our stakeholders. And everyone has a different perspective. And that's what I've learned through my practice is when you work with the different members of the community, you may not have the idea because you're looking at it from this perspective. And when you share that burden with the other stakeholders, you can be enlightened to different avenues of solving problems. And so I think it's very important that we work with all of our stakeholders to come to a solution for the indigent defense crisis.
Thank you.
Question number 3 is, how do you ensure that every individual who appears in your courtroom, regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to justice?
So as I've mentioned, my diverse experience, I've appeared in front of a lot of judges. And so I've seen good judges. I've seen judges that miss the mark from time to time. And I've seen the impact of those decisions on clients. Working as an indigent defense attorney for dependency and for criminal defense, I have seen how that can impact our community. One specific example that I have was a judge that I appeared in front of in a small rural community, made a comment to me after we were successful in defending against the no contact order. I went back into the court administration to get a copy of the order, and the judge came out and said, well, at least I know he had to pay you to come out and defend him. And it took me by surprise, and it was really off-putting. Just to be frank, it was how biased, and this wasn't a gentleman from a marginalized community, but it was nonetheless someone who was essentially a property owner that didn't live in the county. So he had a vacation home in the county. And it became very clear throughout the process that the folks in the county didn't care for my client, up to the judge even making the comment that at least he had to pay to defend this. And it struck me as this is something that I would never want I'm glad my client wasn't with me to hear that, because I think that would be devastating to a member of the community, whether they live there or not. They are still coming before the court, and they shouldn't have to feel that they are being treated unfairly. And I don't think there's any question that they were treated unfairly in that situation. And so those incidents where they've been far and few between, but they stick with me, and they have kind of molded my practice to making sure that when I see some kind of bias, whether it's racial bias or religious bias or any other discrimination that's occurring, it influences me to even fight that much harder to make sure that that doesn't occur. As a judge pro tem, like I said, I like to come in and prepare for my dockets beforehand as best I can, but I believe that a judicial officer needs to be prepared but not decided. And so we fall into a trap. I think it's easy to fall into a trap of preparing, and you read everything and you make your mind, I know what's happening here. And I think it's important to be prepared, but not to make sure that you do not make a decision before you've heard, because there's been a number of times, even as a pro tem, that I've had an idea of where, okay, I think I know the landscape here. And then you get the argument from either the attorney or sometimes from the pro se party. And you say, I'm glad I didn't make my decision because I was heading down the wrong path. And I think it's very important that we as judicial officers come into our dockets, come into our hearings with an open mind, because that is what we are required to do. And so I make sure that when I see an individual in front of me, I don't take into account anything other than realistically, are they here and they're punctual, we're ready to proceed? I try to avoid favoritism when it's sometimes a hard trap to avoid when you're familiar with attorneys that come in front of you all the time and say, oh, well, here, Mr. So-and-so, I'm going to bring you forward and let's take care of your matter. And sometimes that's appropriate, but other times you have to recognize that the younger attorneys that are here in front of you are just as important, that the pro se litigants are just as important. And everyone should have the same opportunity and not be given preferential treatment, not be treated as though they're less important. And so you have to maintain courtroom efficiency as well. And so trying to take matters that are shorter, that you know from your preparation, this is going to be a very quick matter, or asking if there's going to be continuances so you can get those folks on their way so that they're not sitting in a courtroom for 4 or 5 hours at a time waiting for their 10-second hearing while someone's making a 15-minute argument. So I try to balance efficiency with making sure that everyone feels that they are no more or less important than anybody else while coming before me. And I've represented a number of clients from marginalized communities, and I've done so in the dependency world, which, as I said, you spend more time with them as their voice in court and their voice against the department and the state entity. It does become a bit hard not to internalize some of their struggles that you have. And when you see biases that they're facing, you personalize it to an extent of saying, this isn't acceptable. We're having bias that's being portrayed. And while it's not directed at me, I am the mouthpiece for the person that it is directed at. And so that has kind of governed my experience and my representation and my philosophy as being a judicial officer is making sure that I'm not engaging in any of those biases and keeping myself open to ongoing training, cultural sensitivity training. Specifically, I've worked with the Chukis community, which we have a fairly large Chukis community in Clark County. And there's issues in their representation that are unique in that the language, while the island is small, they have multiple dialects. And I've learned this through my representation of Chukis clients. Their dialects are interpreters. There's, I believe, 3 in the entire state. And so we have a very limited interpreter resource. However, they don't always speak both dialects. And I've represented clients where, thankfully, I had a relative that was willing to sit in on some meetings and explain the interpreter we have, while doing a great job, is interpreting to a different dialect, and that my client wasn't really understanding what was being said. And they would have discussions, and I'd have discussions with the relative, and they were able to kind of explain some of these distinctive features. And I think it's important as judicial officers that we educate ourselves. There's also some cultural issues, in particular with the Chukis community, where there's some deference to authority, and they'll nod and indicate either agreement or understanding as a means of being polite. And so I've had to learn in dealing with that, okay, we have to take the extra steps to make sure that we are understanding, and that we're understanding the cultural implications of these folks that are appearing in front of us or that I'm representing, because the yes that we see from a nod doesn't necessarily mean what our culture here means. And the words directly translated don't have words. It's a limited language as well. There's less words. And so certain words just come out in English. Only you'll hear it during the translation. And they're important terms, and they're important words that clearly these aren't being interpreted. They don't have the word to understand it. And I think that exists in a number of cultures and a number of, especially language barriers, where we have interpreter needs. And so I think it's up to the judges to make sure that they are educating themselves, so that when they have someone appear in front of them, that they make sure that the accommodations that can be made are being made. And I think our district court's doing an excellent job. We have staff interpreters. I believe we just secured a staff Chukis interpreter as well, which is excellent. As someone who's represented a number of Chukis clients, I think having access to those services is immensely helpful. And so I think district court is making great strides in that area, and I hope to see that continue. And so having that education, I think, helps promote equal access, making sure that these people are heard, making sure they feel respected, and that they understand the process.
Thank you. Question number 4, please describe a specific instance where you were faced with a difficult decision or challenging situation that garnered significant public or professional scrutiny and pushback. How did you navigate that situation? What principles guided your actions, and what, if anything, would you do differently looking back?
So I look at this question or listen to this question, and I see essentially two issues or two specific examples pop in my head. One was more personal, dealing with my legal ethics. And it goes back to a Chuki's client that I represented, where became abundantly clear that he wasn't understanding the documents I was going over him, even with an interpreter, wasn't understanding the process, but was indicating acknowledgement and agreeing, at least verbally, to the interpreter, to myself. And then discovered that he wasn't. And this is the gentleman whose cousin happened to be able to help me understand that, oh, no, his nod doesn't necessarily mean he's agreeing. He's saying he's heard you, but he's not agreeing. It was a very important discovery for myself. And so I had to take a step back. We were doing a trial where it was one of the first Zoom trials. I think it was the first Zoom trial that I had to do during the COVID pandemic. So we had a number of issues that we were dealing with. And it became abundantly clear that my client wasn't actually understanding, which means he wasn't getting my advice. He wasn't getting the opportunity to have effective counsel at that time. So we had to pause. I had to pause and request a recess to take additional time to speak with him. And where in trial, there's a lot of pressure to get things moving, to finish things. And I had to step back because I discovered that my client just simply wasn't understanding. And so that was a difficulty. What I've done since then is I'm very quick to look for relatives who may have a better grasp of the English language that can assist. I've looked to setting up more appointments earlier on to make sure that the dialect that they're speaking, that my client is speaking, that the interpreter understands that dialect as well. And that hasn't always been the case. And so I have changed my practice there, and that's been a difficult situation. With regard to public scrutiny, I was involved in representing one of the defendants in I think it's one of the largest poaching strings that we had well, it was Clark County, Cowlitz County, and Skamania. I was representing this gentleman in Skamania County, and he was charged with 60 counts of unlawful big game hunting. And so there was a lot of public scrutiny. It was one of the first cases I did where the media was actually coming in, and the comments were very, how can people defend him? He's horrible. He should be put away for life. And I just had to focus, and it wasn't necessarily difficult. My personality has been such that I have a job to do. It's time to do that job. But I think it's very conducive to a judicial position. My job was to defend him, regardless of what he's been charged with, regardless of what the public wants. My job was to provide the best defense possible for this young man, whether I agree with what he did or not. And as a criminal defense attorney, most of the time I don't agree with what my clients are alleged to have been or have been accused of. But the job is to represent them regardless of whether or not the public agrees with you. And I think as a judge, there are going to be times when you have to come to a decision that either the media or the public in general is not going to agree with, because that's what the law dictates. And I think you have to have the wherewithal to face that scrutiny and say, the job I have is to make the legal decision that is required. Whether it's popular doesn't really matter. Whether it's correct and follows the law, and I'm doing my job and my role, and giving the respect to the process, giving the respect to the participants, whether they agree with my ruling or not. That is, I think, one of the fundamentals of being a judge.
Thank you. Question number 5. Beyond your duties on the bench, how do you envision a district court judge actively contributing to the community and fostering public understanding and trust in the judicial system? Now, give us an example of your past involvement that demonstrates this commitment.
I have been practicing dependency, as I said, for about 8 years, and it's an area that I feel very confident in. It's something that I feel that I can give back. And so what I have done in the past, and I've done since, I think, for the last 6 or 7 years, is I teach a course, one of the courses for parents, specifically dads It's designed at kind of giving some instruction. They aren't my clients. They are referred by the department to go take a parenting class. And one of those parenting classes I teach is about the process and kind of strategy and thinking, changing your thought process as a dad that's in this dependency process. And so I've always tried to find where my strengths are and see how I can use those strengths to give back to the areas that is going to be the most impactful. I think when we focus on where do I excel, that I can use that to help other people, that's where it's going to be the most effective. And as a judicial officer, I think it's important that we have a presence in our community. I'm currently on the Clark County Bar Association Board of Trustees. I try to attend as many of the events as possible to get my face out there, to make sure that I'm out with the community and involved. I think as a judicial officer, it's also important to be on the committees. They have some internal committees, the Finance Committee, the Legislative Committee, and working behind the scenes to make sure that the court is providing the services that our community needs and the community desires. And so I think beyond your role on the docket, there's a lot of opportunities there. In particular, community courts and therapeutic courts, when there's graduations, even if you've moved off of that rotation, it's still great to see. And I haven't appeared as a judicial officer there, but as an attorney, to go see clients graduating, to go see the reunification day is a big one in dependency world. To see the judges that come out, and even though they're not on that docket any longer, they're not overseeing that bench, but they were there for your clients and they've created that bond. I think appearing at those graduation ceremonies, at those events that recognize success and celebrate success, I think that's a great way for our judicial officers to engage with the community and show that we're not simply out trying to punish folks but there's a human aspect to it as well, that we are celebrating successes from our community. And so I think that's one of the ways that a judicial officer can really do some outreach to the community and let them know, have some faith in our judicial process and our judicial systems.
What do you see as the unwritten responsibilities of a district court judge? How would you meet them if appointed?
Well, as I mentioned, there's a number of committees that the judges are involved in. I think it's important to be involved in those committees, to take an active role, if you have some exceptional skills in finance, to join the Finance Committee, help us with the funding issues that face the court, the issues that are impacting new legislative rules, and come up with strategies, meet with our stakeholders. In particular, I'm aware there was some issues with our DUI court, where we had some of the lowest enrollment for a period of time just recently. And I believe it was Judge Bartlett had a meeting with the stakeholders, called in the defense bar, called in the prosecuting attorney's office, and said, this is a program that we'd like to see succeed. How do we make that happen? What is it that's preventing referrals? What is it that's preventing defense attorneys from referring their clients or recommending their clients to engage in these programs? And I think that's a very vital role for our judges, is to be involved with the stakeholders, be involved in the committees doing the administrative functions, work with staff, because part of our job as a judicial office is we have to manage the court. That's part of our job. So we have to work with our staff, make sure that things behind the scenes are running smoothly as they can. And if they aren't, to figure out solutions to help our staff, help our court system itself runs as smoothly as possible. Address, during COVID, we had a lot of changes. And so it's dependent on the judge to be able to think on their feet outside of the legal analysis. what are we going to do for solutions to come up with ever-changing landscapes for our courts? And so that's the unwritten, I think, roles of the court is it's so much more than calling balls and strikes in the courtroom. It is how do we make our court more accessible to those who have a difficult time accessing our systems? How do we make our programs work better for our community? And if there are problems or there are issues that need to be addressed, coming up with solutions and looking to folks who have potentially more knowledge on certain aspects of that than the judge might. And judges are human. They're not going to know everything. And so we have to rely on our other stakeholders. We have to rely on the jail services to come up with solutions. We had jail booths were created with to avoid the contact problems that COVID created. And so coming up with Zoom, doing those alternatives, coming up with therapeutic courts and making pivots to make those programs better. I think that's the unwritten role of the judicial officers.
Thank you. Question 7, describe your personal decision-making process.
As I said earlier, when I analyze a legal case that comes before me, I try to play devil's advocate, look at it from all sides as best I can, because I think the only way you can advise a client efficiently and effectively is by looking not only at the strengths of your own case and at the weaknesses of your own case. That's very important, but you have to look at all sides, try and view it from as many perspectives as possible. And so my decision-making process is always guided in trying to see from every angle that I can what maybe should happen, maybe what is likely to happen, whether it should or not, and make decisions based on the entirety of the record, all of the information. And as a judge, I think you do have the benefit of you have counsel or parties coming before you and providing both sides. So you get all the information, whereas as an attorney, you have to do your best with guessing sometimes as to what the other side's strategy is going to be. But as a judge, as a judicial officer, you get to hear it. They bring it forward to you and you can sit there and you can listen and see this is the strength of this case. And here's the strengths of this other side. And make that decision after having the full facts. And that's kind of goes back to my preparedness as well. We want to be prepared, but not overly prepared to the extent that we've made a decision. And so being open-minded, being ready to receive information from all parties and from all interested parties that have the standing to come before you as a judge. And so that's my decision-making philosophy, I guess.
Great. Thank you very much. We've come to the last question, and I'll ask you it. Is there anything we've not discussed that you believe could be important in making the decision for district court? And am I reading? I'm reading. I slipped into another question here. Is there anything we have not discussed that you would like us to know when considering you for this position? And do you have any questions of us?
I would say that, well, I wasn't born here in this county. My wife was, and I chose to come to Clark County, and I've enjoyed it immensely. It is my home now. I am raising my kids here, and I want to provide the security that our community deserves, the security that I would want to see, that I want my kids to be able to expect, to provide an example to them of how the justice system should work, that our community can count on our judicial officers to be fair and respectful and unbiased and approach things the way I think it's intended, which is as a neutral, to give everybody their day in court, to treat them with respect so that it demonstrates to my children, demonstrates to our community that that we can, even if we disagree, we can be respectful. We can get along at least to an extent, and let everybody feel that they've gotten a fair shake. They may not agree with the result, but that they've been listened to, that they've been taken seriously, and that there is a reason behind any decision that I make. And so I would just say that I would like the council to consider that this is where I've chosen to call home. I have a very big interest in making this community secure, making this community feel represented, feel heard, and very much a just community. With regard to questions, I would ask essentially this. You are one of the big shareholders in district court. What would you say is a effective partnership? How do you view the partnership that I believe it's integral to have between the judiciary and council? You're the legislative body for our county. We're the judicial body for the county. How do you envision the partnership between the judges and council?
Does anyone want to go first? Well, thank you for that question. I chair the Law and Justice Council, and I think that has been a very good forum for that collaboration. So I think bringing things to the table there is very important. And I think for the council's perspective, how we fund everything, and I think we're very much aware of all of the components need to be able to fully function, for the whole thing to function. I don't know that the public really understands that as well as maybe they could. So I think helping the public be more aware of how the whole system works could be a very helpful thing. And then participating in the Law and Justice Council. And I think that's been more of a collaboration in this past year than maybe there has been in the past. So those are just a couple of thoughts I have.
Thank you.
I would say this is important. Communication. We can't be aware of the challenge that exists if we're not there, and nobody brings it up to us. So communication, I think, is the single largest, most important factor in making sure that we are able to work well together and make sure that the community has all of its needs filled.
I agree with both Chair and Councillor Young. The open line of communication and collaboration is essential to, serving our community as well as we possibly can. So I don't serve on the same committee you do, but, the chair does inform us of what's going on. And so that's very, very helpful. But some of us would love to hear from you directly as well. So I keep that open line of communication going. Thank you.
Councillor Belcott, do you have anything to add?
Yeah, just to echo communication, I mean, we interact with the courts and the clerk, and I know several candidates today have brought up budgetary concerns, and that's something that comes to council all the time. So just communicating with us so that we know how to assist and partner with the judges and the courts is very, very important.
Great, thank you. And I really just want to thank you again for your application, for coming in and sharing this information with us. I want to thank you for the service that you provide the community. It's very important. We have one more interview to conduct. We'll go into executive session and share our thoughts, then come out probably around 3 o'clock and take whatever action we might be taking. So you could know as early as around 3 o'clock what the decision is, and you're welcome to tune in or come back and join us for that. Okay, I think that's about it. So thanks again, and it was very nice to meet you.
It was very nice meeting you. Thank you for the opportunity.
So so minutes before our next interview. Okay, council is about to begin our final interview for district court judge.
Oh.
Hello and welcome. Be sure and push your button there. So welcome. This is our final interview of the day with Leslie Lopez. So good to see you.
See you all as well. Thank you.
Thank you. So just a few opening remarks. Thank you very much for applying for this position. We appreciate the time that you're taking to be with us today. We have 45 minutes and 8 questions, so you can pace yourself on that. It seems to be working out so far today. We'll start with introductions. I think there may be no need for introductions, or it would be good just to remind everyone who we are. So I'm Sue Marshall. I chair the council and represent District 5, the northern half of the county.
Counselor Young, represent.
Councilor Fuentes, District 3.
Counselor Michelle Belcott, District 2.
Well, hello,
Okay.
I'm Leslie Lopez. Nice to see all of you, and Counselor Fuentes, nice to meet you, and the others of you, I think I know. So
Yep.
thank you.
Yep. Thank you. Good to see you. I'll start out with the first question. Given the description of this position, please tell us how your unique qualifications and experience make you the most suitable candidate for a district court judge, and articulate your primary motivations for seeking this particular role.
Right, thank you. That's a good question. I think I'll actually start with my primary motivation. So my primary motivation is, you've probably heard this before, but district court truly is the people's court. It's the one court where, in my opinion, the people are the most vulnerable. that come into court because they typically haven't been involved in the court process before, whether it is for a criminal matter or it's a small claims matter or they're seeking a civil protection order. Those types of things, people don't do those unless there's some type of issue that's happening and they're scared and they don't understand the process. As a district court commissioner, enjoy is not the word, but I feel what we do is important and means something, is meaningful, because part of my job as a commissioner is to explain the process. I can't give them legal advice, although many of them want me to. I can't give them legal advice, but I can at least explain why we're here. This is what we're going to do. If it's a criminal matter, making sure that they've qualified for court-appointed counsel, getting them counsel to talk with, if not, setting their matter over to give them time to hire one, and just really explain that process. It's my passion. I feel like my life experience and work experience has really brought me to this point, and I'm grateful to District Court Bench for giving me the opportunity to be a commissioner. In terms of my qualifications, you've read in my materials, I'm not the typical candidate. I didn't go straight from high school to college to law school. Instead, I worked hard and raised a family and took a long time through that process. During that process, I also made a point to volunteer where I could. And I don't come from a particular perspective. In other words, not particularly from a prosecutor or from a defense. I've worked with all different types of people, types of situations, and I feel that it gives me the unique perspective to be open-minded. And I'm of the firm belief that every person who walks into my courtroom is entitled to dignity and respect, even when they are upset with me or don't like my decision. So that's why I feel that plus I'm already doing the job. And before that, I was a Superior Court and District Court pro tem before that, handling difficult dockets such as the unlawful detainer and civil protection order dockets, which are the most upsetting and emotional to the people involved.
Thank you for that, Leslie.
Oh, I'm jumping ahead.
Yes, you are. Question
Sure, it's
number
been a
two.
long day.
Describe your direct experience with the specific dockets and functions of the district court, such as presiding over jury trials, protection orders, or various criminal and civil hearings. Now, based on this experience, what is one significant challenge or opportunity you foresee for the Clark County District Court in the next 5 years? And how would you, if selected as a judge, propose to address it?
All right, thank you. As far as dockets are concerned, I handle all of the same dockets as a district court judge, except for criminal jury trials. That's pursuant to statute. So I handle arraignments, video arraignments, domestic violence arraignments, change of plea dockets, anything related to a criminal case that leads up to trial. For instance, I had one, it's called a mandatory pretrial docket, and there were, I believe, about 42 defendants, and they had multiple cases, one of which had 5 cases. And we had, actually, that was a video arraignment after the holiday weekend. And there's a lot of moving pieces. Part of being a commissioner is being in the courtroom, figuring out what's happening, having the decorum to be calm, understanding what people need. We needed many different interpreters. We needed different attorneys. And so trying to manage all of that. In terms of, we handle the protection orders. I've handled them both in Superior Court and District Court multiple times. The protection orders are due every other week. I'm in court morning and afternoon, almost 5 days a week. And the days that I'm not in court, we use those for preparing. In terms of criminal trials, I did try some cases when I was with the Multnomah County District Attorney's Office. I did not try cases in district court prior to coming to district court. However, I was a trial attorney in the civil arena, and in that capacity represented law enforcement in constitutional rights cases involving questions of probable cause, search and seizure, all of those same types of issues that occur during a criminal trial. So I feel well versed to be able to handle any of those. Did that answer your question? Oh, the other part was,
The second part, yeah. Did you need me to repeat it?
so the second part is, and I'm sure you're aware of this also, but we have new mandates for Indigent Defense Council. And I will say district court has more and more cases filed every year. And the fact that the requirements for indigent defense means there needs to be more defense attorneys because they can only have so many cases. It's going to be an issue that everyone is going to have to work on. I have the unique experience that I've worked with the county. I've worked with all of the partners of the judicial process, and including the council. I understand budget. I understand monetary issues. I also understand how important it is to collaborate with others. I understand the separation of powers. And if I was a district court judge, while having that independent judicial authority, I know that I can work collaboratively with others to try and work on solutions. I did that when I was the chief civil deputy. I worked with almost all of the departments and elected officials in Clark County and was able to work on some very difficult and sensitive issues and try to work on solutions.
Now it's my turn.
Okay.
The third question, how do you ensure that every individual who appears in your courtroom, regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to justice?
Okay, I didn't hear the first part.
How do you ensure that every individual who appears in your courtroom, you want me to continue?
Yes.
Sure. Regardless of their background, socioeconomic status, language, or the nature of their case, receives fair, impartial, and respectful treatment and feels that they have equal access to
All right,
justice.
thank you. I think I missed the nature of the
They're long
case.
questions.
Okay, thank you. That's the ultimate question, really. I mean, that's what the judicial system is all about, is making sure that people feel that they've been given fair and equitable treatment. The biggest thing that I do in trying to determine or making certain that people feel that they're being treated fairly and equitably, regardless of where they come from, is I try to meet them where they are. I try to pay attention. There are some times when we know someone needs an interpreter, but we don't always know that. And so when it seems as though there may be some issue communicating, I might inquire to see if they need an interpreter. In terms of socioeconomic and facts of the case, my job is to be fair and equitable. So I take all of the information and apply it to the law. And my hope is that the folks that come into my courtroom understand that I am treating them the same as someone else who would have that same type of situation. Now, some of that issue, though, is that every case is different. And so I do my best to listen to both the prosecutor and the defendant and the defense counsel and get all of the information I can and make that decision. I also make a point of explaining my decision, and that's best explained during the civil protection or small claims trials, because oftentimes people come to court in their mind, they should win. Otherwise, they wouldn't be there. And so they're oftentimes upset when that doesn't happen. So I try to make a point of explaining, okay, this was the burden of proof. This is what I saw. You didn't meet that burden. In some of my civil protection order cases, I've actually written opinions because sometimes it was a complicated issue and I wanted to lay it out in paper to make sure they understand that. So that's my process. Did that answer your question?
Yep. Number 4, please describe a specific instance where you were faced with a difficult decision or a challenging situation that garnered significant public or professional scrutiny and pushback. How did you navigate that situation? What principles guided your actions? And what, if anything, would you do differently looking back?
Very good question. I make difficult decisions every day. I would say that the most difficult cases are in the criminal realm, from my perspective, are the domestic violence cases. There are many times, based on the facts, that I feel it is appropriate to issue a no contact order, a protection order for the victim. And there are many times when that victim does not want the protection order. Those are very difficult, and it's difficult to explain why I'm entering that when they don't want it. What I do in that instance is I try to explain to them they have the ability to file something with the court to ask for that decision to be reviewed. And that often does happen. And then that next judicial officer will then review to see what's happening with the case, to see if that should be changed. In terms, I had one the other day. It was a video arraignment where a gentleman had been charged with some crimes. He qualified for court-appointed counsel. He spoke with court-appointed counsel. He then decided he wanted to represent himself and he wanted to plead guilty. Wanted to make sure that he understood the consequences, and we explained that. I had him speak with the prosecutor to see if they wanted to come to some sort of agreement. He said he didn't want counsel. He then wanted to plead guilty. He does have that right to do that at arraignment if he wants to. We then proceeded with the arraignment after I explained over and over why he should have an attorney, and he waived his right to have an attorney. We then went through the plea process, and during the plea process, it became very clear to me that he was not fully understanding what was happening. He was very upset, calling the court names, saying that he was being persecuted and this sort of thing. So at that point, after making some inquiry, I decided he needed to have an evaluation for capacity issues. And so we did that. I then reappointed counsel, and that was a difficult process. And I think if I could have done something differently, it probably would have been to inquire more at the beginning. But it wasn't clear to me right at the beginning that he was having issues understanding. Prior to becoming a commissioner, working in 2022, there was a very distinct situation that was a lot of publicity and pushback. There was a mini initiative that was filed concerning COVID practices at that time. And I, as counsel to the county council, gave an opinion as to how that should be handled. The council decided to waive the attorney-client privilege, and I was then at a public meeting with many, many people and described that during that process. And there was a lot of pushback from that. I wouldn't change the way that that happened, but I'm not immune to criticism or pushback. I think for me, what's my responsibility is to still act with decorum despite whatever pushback there is. And then if I do need to examine what needs to be done differently, to go ahead and implement that.
Thank you, Leslie. Question number 5. Beyond your duties on the bench, how do you envision a district court judge actively contributing to the community and fostering public understanding and trust in the judicial system? Can you provide an example of your past involvement that demonstrates that commitment?
That's a great question. I do think that that is the responsibility of a district court judge. In my past, I did that in terms of, well, volunteering, well, wasn't volunteering, but being a pro tem judge, pro tem commissioner. Also in my past, in having worked with different people who have gone through different situations, such as assisting with petitioners who are wanting a protection order, helping them fill those out, doing pro bono work with family law, those types of things. In my role currently, I think it's important to educate. I actually received letters from 3 middle school students, and it was a history assignment, and they inquired as to how I could help explain some concerns they had with immigration issues. I wanted to make sure that I responded, but I didn't want to respond to them directly. So I reached out to their teacher and indicated that a response to that particular question is outside my wheelhouse. That's not something that is part of my job as a commissioner. But I did indicate to the teacher that I would enjoy the opportunity to come and speak with the students to talk about my role as a commissioner and also how the different branches of government work with each other and how if there's something they want to change, what they could do to do that. That happened at the end of the school year, so I'm still waiting to hear back this year. But that's just one example that I think is important, as well as explaining. Also, I'm on the diversity and public outreach community for the district and municipal courts. And one of those is, for the public outreach, it's called You've Been Served. It's where local legislators are invited to learn about district court and what is needed. And so I'm actually hosting that this year. And so it's those types of things right, thanks.
All right, thanks, Leslie. On to question 6. What do you see as the unwritten responsibilities of a district court judge? How would you meet them if appointed?
It's a good question. The unwritten rules would include working with others. In district court, we have an amazing group of individuals that do all sorts of jobs, responsibilities. As a judge needs to be a leader, but needs to be a leader that is open to others, open to discussion, allowing people to come and bring issues to them, and showing the people that work at district court that compassion and kindness, that's required. Also, being collaborative if there are issues that come up. Some of the other unwritten rules are showing decorum in all places, not just in the courtroom, but outside the courtroom. You know, how is a district court judge living their life outside? Are they treating people with respect? Are they volunteering? I volunteer with the Friends of the Ridgefield National Wildlife Refuge. The Clark County Bar Association had a wonderful opportunity where we planted, I believe it was corn seeds we planted at Heritage Farm. And it's just things like that, getting out in the community, showing okay, currently I'm a judicial officer, but I'm a regular person. I can pitch in like everybody else. I think that's important because I think so many times people who come into court, they see a judge, they're frightened. I see it all the time. They're nervous. I tell them just like, let's just take a moment. Let's take a breath and just relax. And it does help because we're people just like them. And I see a judicial officer. It's not about me. It's about the people. It's about serving the people. It's not a status symbol. And that's whether I'm a commissioner or a judge, that's my role. And I will continue to do that.
Thank you, Leslie. For question 7, please describe your personal decision-making process.
Well, that's a good question. I will say many times decisions have to be made very quickly because when we have a lot of defendants, a lot of family members who are there isn't a lot of time to make decisions. But I also will say we go until every decision's made. I had a docket last week that went from 12:30 to 6, and that's just what you do. So the first decision is knowing what the decision is I'm making. In other words, is it a civil protection order docket? Is it an arraignment? Is it a change of plea? Is it a small claims action? Is it someone who's changing their name? Because each one of those dockets involves a different decision-making process, depending on what that question is. And I already know that before I get there because I prepare for the docket. But once I know that, I know what information I need to know to make that decision. For instance, when I do a civil protection docket, I explain to the parties why we're here and that I understand that they don't want to be here, that it's tough feelings between the parties. I tell them I expect that even though you don't want to be here and don't want to be that person's friend per se, can we all agree that we can at least be civil to each other? No eye rolling, no pointing, that sort of thing. And I get them to agree to it and they actually follow it. Sometimes I have to call them out, but that's part of that decision process. And I explain the decision process to them. I say, okay, the person who filed the petition, you're going to go first. You have the burden. And I don't say preponderance of the evidence because no one knows what that means. I say more likely than not, or 51%, that the other person committed unlawful harassment. So I say, okay, you start. And then I tell the other person, the respondent, do not say anything, don't interrupt, write some notes. You'll get a chance to respond. And then at the end, the petitioner has another chance. I tell them I will take all of that information and then I will make a decision. And that once I make their decision, they will not have anything more to say. And then when I tell them, I use that information, make the decision, explain it to them, and then also explain their appeal rights. You don't agree with my decision, you do have that right to appeal. You have 30 days to do that. I will say I've been fortunate in civil protection order. I had one where an individual was, a lot of times it's neighbors, and these two neighbors were very upset. The one that lost was very upset. I did not find that they had met the burden for a protection order. I usually talk with them afterwards to say, I understand you don't want to talk to each other, but you've been neighbors a long time. And this is not a judicial decision, but just encouraging them to either try to work it out or just don't talk to each other. Well, as it turned out, the one neighbor unfortunately, had lost her father. The other neighbor had recently lost her husband, and they were actually able online to talk to each other and said they would be there for each other. And for me, people come to court because they want someone to listen. And as part of that listening, as part of that decision-making process, is making sure I am listening to everything that people have said. If it's in a criminal case, I hear what the prosecutor has to say. I hear what the defense counsel has to say, and then I make my ruling.
Okay, we've come to the last question.
Oh, okay.
I know it went fast, didn't it?
It did.
Is there anything we've not discussed that you would like us to know when considering you for this position? And do you have any questions of us?
I think the most important thing I want you to know is that the job of a judicial officer is important. But as I said earlier, it is not a right. No one's entitled to that job. But I love the job. I sincerely feel that all of my life experience and my work experience has brought me here. And I have a love for people generally. I've had many different situations in my life, and I try to handle them with humility, grace, and I try to extend that to the others before me. And I will tell you, there is nothing more satisfying than having someone come in the courtroom and they feel that they've been heard. And to me, that's what it's about, is making sure they understand the process, they've been seen, they've been heard, even though they may not get what it is they're seeking. And I will do my best, even as a commissioner, to keep doing what I'm doing, to keep reaching out, learning more. I guess I know I feel like I'm gushing here, but truly it is my passion. You probably caught that. In terms of questions for you, my question is, have I fully answered your questions? Go ahead.
You have for me, so thank you.
Okay.
Yeah, I think you have for me too. And you've also commented to us that you've thought our questions were good. So appreciate that.
They were very interesting and insightful too, because I think oftentimes, everyone I think knows what Superior Court does, but I think District Court, it's not always clear what happens in District Court. So,
Councillor Young or Councillor Belcott, did you have any, were the questions answered satisfactorily?
Absolutely.
Okay.
so I think I saw what was next steps, but what are next steps?
Next steps, that's what I was going to get to. So this is a public process. We will, after this, our final interview, go into executive session and take some time to talk amongst ourselves. The schedule has us coming back at 3:00 to again go into a public session where we may make decisions on the actual positions, or if we need more information. There's several options that we can take, but at 3:00, although I think we've got a lot of information to weigh here. And as it's a public meeting, you can tune in, come back and hear what we have to say around 3.
All right. Well, thank you very much. I really appreciate your time and consideration.
Thank you, and thank you very much, Leslie. We recognize and really appreciate the service you provide for this community. So we're grateful for you applying for this.
Thank you. I appreciate that.
Okay, and with that, I believe we'll go into executive session. I may take a couple of minutes to get there, though, so maybe we could start like 2:40, 2:40? Okay, sounds good. And we'll come back, well, let's say 3:00. That's what we've been saying all day. If it takes longer, we'll extend. And there'll be some after action.
Chair, I believe the county manager has a question.
Yes, go ahead. Thank you, Councilor Belcott.
I just wanted to clarify for the record, because we did notice the executive session for 15 minutes. So if it's 2:40 to 3, I just want to clarify for the record, it'll be a 20-minute executive session.
Yes, that sounds good. Thank you.
Thank you.
Good afternoon. The council chair has asked us to announce that executive session will be extended for an additional 10 minutes and open session will resume at 3:10. Thank you.
Okay, welcome everyone. Council has returned from the executive session, and I would just like to make a couple of comments before we make any motions, and that is I think as a council really understand the significance of the decision that we're making, that for all of the candidates, and the candidates are outstanding, that you've made it very difficult for us, and that this is the culmination of a career. So just know that we take this decision very, very carefully. We will be taking, there are 2 positions open. We'll vote on each one. We'll take each one separately. We are going to open, just in terms of the process, we'll open for nominations, and then we'll vote on those that have been nominated for each of the positions one at a time. It could be that more than one candidate gets a majority vote, in which case I will ask the council if they would like to have a runoff vote, or if there's a desire to have a second interview, or to have some follow-up interview. So that's how we intend to proceed. And I guess with that, are there any nominations for Judge Langdorf's position that he will be retiring September 30th? So we'll start with that position.
Chair, I'd like to nominate Aaron Priest.
Okay, thank you. Is there a second? I'll second that. Are there other nominations?
Chair,
Yes, please.
I'd like to nominate Liz Lopez.
I'll
Okay,
second.
nominated and seconded. Are there any other nominations? Oh, I think we need another microphone. Here, you can just take this one for the moment.
Chair, I'd like to nominate Greg Sheeny.
Second.
Are there any other nominations for this position at this time? Okay, with
Chair.
that, oh, go ahead.
Apologize, I'm a little late there. One more nomination. I'd like to nominate Ryan Busby.
Okay, so we'll take them one at a time. We have 4 candidates here. Were there any other nominations at this point? Yes, Counselor Fuentes seconded. Oh, you didn't. Is there a second for Busby?
Second.
There you did. Now you did. Okay, moved and seconded. Okay, well, let's start from the beginning. All those in favor of Aaron Priest, say aye.
Aye.
Aye. There's 2 votes. So not moving on. All those in favor of Leslie Lopez, say aye.
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 Aye. All those for Greg Cheney,
Aye.
Aye.
all those for, what's Busby's last name? Ryan Busby.
Aye.
Okay, 2. So out of this round, we have Leslie Lopez. Congratulations, Leslie Lopez.
So this is official, right?
Well, she's the only one that got a majority, so it is official.
Congratulations, Leslie Lopez.
Okay, there's another position yet to go. That begins December 31st. So are there any nominations?
I would like to nominate Aaron Priest.
I'll second that. Other nominations?
Chair,
Yes.
I'd like to nominate Greg Sheeney and, well, I'll do one at a time. Greg Sheeney.
Greg Cheney has been nominated. Is there a second?
Second.
Okay, nominated and seconded. I would like to nominate Megan Payton. Is there a second?
Second.
Moved and seconded. Okay. Other nominations?
I'll nominate Ryan Busby.
Ryan Busby. Is there a second? Okay, no second. Are there any other nominations? Okay, so our candidates for this position are Aaron Priest, Greg Cheney, Megan Payton. Okay, we'll start with Aaron. All those in favor of Aaron, say aye.
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 That's 2. Is there 3? Was Belcott? Okay, I didn't hear you, Councillor Belcott. I was trying to wait to hear that, so thank you. So there's 3 there. All those in favor of Greg Cheney, say aye.
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 2 votes. All those in favor of Megan Payton,
Aye.
Aye.
aye. Okay, so we have a tie now between Aaron Priest and Megan Payton. So we can have a runoff vote, or if the council would like to, I'll give you a choice here, runoff vote, or would you like to bring them back for a second interview? Do you have a preference there?
How about a second interview?
Second interview. Okay.
I'd like to agree, but
Okay, we're having trouble with the mics.
I also support a second interview.
second interview. So we've got backups all around. So hearing from the council, did you want to weigh in on the second interview, Counselor Young?
I'm okay with that, or we could also figure out questions and ask them to electronically give us their answers. I'm okay either way.
It has to be an open meeting, doesn't it? It has to be an open meeting. Okay.
It can be done online.
Right.
Public meeting, right. Okay, so it sounds like it's the desire of the council to have a second interview with Aaron Priest and Megan Payton. And we'll work out the logistics of that and let everyone know. So again, thanks to all of the candidates. This has been very tough. We are grateful for the service that you've all provided our community. I think the passion that you all share for law and justice was very evident. So thank you. And with that, without objection, this meeting is adjourned.